together with the certificate of financial implication.
Thank you. Thank you, Right Honorable Speaker. In accordance with Rule 128 of the Rules of Procedure of Parliament of Uganda, I beg to move that the bill entitled the Valuation Bill 2024 be read for the first time.
Thank you.
The Valuation Bill 2024.
I do the certificate. Right Honorable Speaker, in accordance with Section 76 of the Public Finance Management Act, Cap 171, and Rule 118 of the Rules of Procedure of Parliament of Uganda, I beg to lay on table the Certificate of Financial Implication for the Valuation Bill 2024.
Thank you. Pursuant to Rule 129(1) of the Rules of Procedure, the bill stands referred to Committee of Fiscal Infrastructure and report back to this House as per Rule 129(2) of the Rules of Procedure. Thank you.
Item 4 on the order paper, laying of papers, the Tier 4 Microfinance Institutions and Money Lenders, Lending Conditions Regulations 2024.
Honorable members, pursuant to Section 112, subsection 2D of the Tier 4 Microfinance Institution and Money Lenders Act 2016, I now invite the Minister of Finance, Planning and Economic Development to table the regulations, but in this case, it has been delegated to the Prime Minister. They wrote to me.
Right Honorable Speaker, the Tier 4 Microfinance Institutions and Money Lenders, Lending Conditions Regulation 2024 is laid. I beg to lay.
Thank you. Honorable members, the Parent Act does not require parliamentary approval for the regulations to take effect. The regulations that have been tabled is for information purpose for the House. Thank you. Honorable Lop.
Thank you, Right Honorable Speaker. Honorable Speaker, normally when I stand here, I tend to complain and raise issues of concern. Even in the brief report I'm going to read here, there's a few complaints and concerns. Allow me to also begin by complimenting government. I don't do this often. So I also want to compliment government for providing security to the demonstrators we saw yesterday. It's a good thing when the constitution is followed to the letter. I don't agree with the reason they were demonstrating and some of the language used because they were threatening to beat up some members and so on. I hope police now investigate some of those indiscipline cases that happened within a peaceful protest, yeah? But the idea of Ugandans peacefully protesting and they are protected is a good thing. I hope that government will keep doing this for all other intending protesters. So government, today we have given you your flowers. Even though I learned that as those who were peacefully demonstrating and were protected by police, there are some others who are even much fewer that were being beaten up. So please don't put us in a difficult situation. We want to keep giving you flowers every so often, yeah? Keep doing that. Honorable Speaker, I rise to present a very brief report on an oversight visit that I carried out together with the shadow ministers to Inspire Africa Coffee Factory. The Office of the Leader of the Opposition organized an oversight visit to Inspire Africa Coffee Factory in Tungamo District. I undertook this oversight visit on 11th December 2024, together with shadow ministers. The visit was in line with Section 6E1 of the Administration of Parliament Amendment Act of 2005 that empowers the leader of the opposition to play the oversight role and keep the government in check. During the financial year 2023-2024, government undertook to establish a tertiary hub for last mile coffee value addition in Tungamo District through the Science, Technology and Innovation Secretariat in the Office of the President under a private partnership arrangement with the Coffee Investment Consortium Uganda and Inspire Africa Coffee, both privately registered entities. The construction of this coffee value addition facility began in October of 2023 and had been projected to be completed by December 2024. We were told that the factory is expected to produce various coffee products, including instant coffee, drip coffee, malt coffee, coffee energy drinks, as well as beauty cosmetics. However, since this strategic government intervention was initiated, various stakeholders, as well as policymakers, have expressed concerns with respect to the implementation arrangements. Some of these concerns include: 1, rationale followed to establish this coffee value addition factory in Tungamo. Number 2, the selection criteria followed to procure the private investor. 3, the reason behind the decision by government to support the building of a factory, a coffee factory in Tungamo District, while not paying attention to other areas known to produce a lot of coffee in Uganda. 4, capital investment. The exact amount of money that the government of Uganda is injecting into this project, because that's not known yet. And 5, projected economic benefits in terms of the anticipated employment opportunities as well as export revenues. Therefore, the primary objective of this oversight visit was to further interrogate and verify all matters related to the above mentioned concerns as elaborated briefly before. During the financial year 2023, government earmarked and allocated 37 billion shillings, that's about $10 million US, in the national budget to support coffee value chain development under a newly created vote 167 in the Science, Technology and Innovation Secretariat in the Office of the President. Also, according to the annual budget estimates of financial year 2024-2025, an additional 75 billion was provided for in the corrigenda to the budget for financial year 2024-2025 and approved by Parliament to support coffee value addition initiatives. To date, a total of 112 billion shillings has been appropriated by Parliament towards support to coffee value addition initiatives. Some of these initiatives include promotion of Uganda coffee globally through coffee trade hubs and establishment of a tertiary hub for last mile coffee value addition in Tungamo District, implemented by Inspire Africa Coffee, which according to Mr. Nelson Tugume, the proprietor, is at an estimated cost of $122 million US. That's about 451 billion Uganda shillings. It is important to note that these coffee value addition initiatives are not directly implemented by government, but rather through partnerships, such as the Presidential Advisory Committee on Exports and Industrial Development, that is chaired by Mr. Audrey Kurawogo, the Senior Presidential Advisor on Special Duties. There is also the Coffee Investment Consortium, a privately registered entity comprising of about 21 coffee companies interested in promoting coffee production and providing value addition in the coffee value chain, and Inspire Africa Coffee, an affiliate of Inspire Africa Group, a human resource organization initially established primarily to address the challenges of youth unemployment on the African continent. Government argues that the initiatives will significantly increase the country's coffee export earnings through export promotion of processed, ready-to-drink coffee instead of the raw coffee beans. However, since the above highlighted coffee value addition initiatives were earmarked and subsequently funded by government, various stakeholders as well as policymakers have expressed serious accountability, legal and policy concerns with regard to the implementation arrangement of these initiatives. Therefore, it was paramount to further interrogate and verify all matters related to the implementation of these initiatives, to ascertain their feasibility and value for public funds in line with the existing legal and policy frameworks. Let me run through the areas of concern, Right Honourable Speaker. 1, funding and transparency queries. In the financial year 2023-2024, the government of Uganda allocated resources through the Science, Technology and Innovation Secretariat under the Office of the President towards the establishment of a modern industrial coffee park in Rashamire Town Council, Ntungamo District. We found that there is no memorandum of understanding between the government of Uganda and this private entity. So the manner in which money was extended to this entity is not clear. Honourable Speaker and colleagues, it is wrong for taxpayers' money to be spent without any clearly defined binding relationship between the government and any entity, and in this case, Inspire Africa Coffee, and no documentation whatsoever. The proprietor told us that there is a co-investment arrangement that was ongoing between the parties, that's government and them, but there was no clarity on whether this arrangement would result into a joint shareholding, a grant arrangement, or a bailout. We recommend as follows, together with my colleagues. 1, government should come out clearly on the relationship that is existing between Inspire Africa Coffee and government that warranted the disbursement of public funds to this private entity. Number 2, Parliament should stop any further disbursements to this entity until a clear and rational memorandum of understanding is reached at between government and this entity. Number 3, government ought to come out with a clear procedure on how private entities can get government support. Uganda has a lot of young and innovative entrepreneurs who only lack funding. If the government comes out clearly on the formalities, then more Ugandans could benefit as opposed to just a few. The other concern is unfulfilled government commitments. Uganda is currently the leading coffee exporter in Africa and the second largest coffee producer in Africa, having exported 6.13 million bags in financial year 2023-2024, valued at over 1.14 billion US dollars. In order to handle the value additional call, government stipulated under the National Development Plan, NDP3, that 2 modern industrial coffee factories would be established, one in Bugisu and another one in Uganda, because these are the highest coffee growing regions in the country. These 2 factories were to be constructed by the end of June 2025, when NDP3 would lapse. This was a commitment by government in NDP3. We are coming to the conclusion of NDP3, and Parliament has even passed NDP4. But these plans have not seen the light of day, Right Honourable Speaker. It begs the question, why did government prioritize a private plant in Ntungamo specifically, which is part of Uganda, fine, yet it did not even attempt to implement and fulfill the commitment made in NDP3, which was passed by Parliament. Honourable Speaker, government should budget for, as a recommendation, and embark on fulfilling the commitment it made in NDP3 to build a coffee factory in Bugisu and Central regions. The capacity of Inspire Africa Coffee Factory is small compared to the magnitude of the coffee produced in different parts of the country. Besides, it's not practical to expect farmers to transport their coffee from far-flung districts in the country to Ntungamo for processing. The third concern was uncertainty about the exact amount of money so far injected into this project by government. During our visit, Right Honourable Speaker and colleagues, the proprietor was unclear about how much money government has so far injected into this project. So it becomes difficult to establish the return on investment that the taxpayer will get. For as long as this information is unavailable or kept as a secret, people will keep raising eyebrows about this project. In the quest for accountability, we ought to start by being open about how much money has been injected in this project. There should not be anything to hide by government. The recommendation, Honourable Speaker, is that government should explain to Parliament and to the country how much money has so far been injected into this project, the terms of agreement, how the taxpayer will get value for their tax money. The proprietor said the factory will be completed in March of this year. That's next month. I don't know if that is going to happen. We are waiting. And begin full operations the same month, next month. Assuming that gets to happen, The cost-benefit analysis of investing in this entity should be examined. We need to know. There should be clear terms on what is likely to accrue from this investment. Every coin of taxpayers' money injected into this project must be accounted for because it's taxpayers' money. In conclusion, Right Honorable Speaker, let me state this for the umpteenth time. The idea of government bailing out or offering support to private companies is not a bad one in and of itself. The problem has been that for each of the private companies given money, there's no clear procedure on how this gets to be done. And Right Honorable Speaker, I've tabled those reports here. Atiak Sugar Factory, Day Biopharma, Rocco, and so on and so forth. Additionally, there is never agreement signed between the government and these private entities to spell out the terms and conditions of the support extended. Most disturbingly is that there is usually no value for the money extended to these entities after several years. For as long as these concerns are not attended to, usage of taxpayers' money will continue to be shrouded in mystery. And there will always be suspicion about these bailouts, given that they are accessed by a few people who probably have connections in government. Thank you, Right Honorable Speaker and colleagues.
Thank you. Thank you so much, Leader of Opposition. The House, you've heard what the Leader of Opposition is saying. Doug, we need a proper memorandum of understanding with the people we are giving money. We need to understand what government is doing, whether we are buying shares, whether we are giving them money just to support them. We need an MOU. And then I also want the Committee of Finance, Agriculture, Trade, Budget to take note of the concerns that have been raised by the Leader of Opposition since we are going into the budgeting process. Prime Minister, you have something? On what? You've just come. You've just come. It is not, we are not debating this report. I am telling them to take note of the concerns. This is an oversight report that has been brought by law. It is opening your eyes.
Right Honorable Speaker, I want to thank Lob for those concerns. We've taken note, and as you've directed, Minister of Finance, Minister of Agriculture will be here to give
committees.
The answers.
Committees.
The committees, yes.
Sectoral committees.
To give answers to the questions raised. Thank you.
We actually want them to take note of the issues that are being raised. And on the issues that are being raised, they must report to Parliament, the committees, when they are doing that. Because if Inspire Africa gets money from government, then they should be able to go there and see what is happening. But that first, we must regularize the relationship between Inspire and government and Uganda. Yes. Honourable members, in the public gallery this afternoon we have a delegation of Africa Friendship Association from Istanbul, Turkey. You're most welcome. Thank you for coming. You're welcome to Parliament of Uganda. Have a seat. They are here to witness our proceedings. Then thank you. Next, yes, Jonah.
Thank you, Right Honourable Speaker. Madam Speaker, I've been here, and the Leader of the Opposition has had so many of these oversight visits, and he has been producing good reports to this House. Without prejudice to your ruling, I would suggest, Madam Speaker, that you do a formal referral of this report to those committees formally, so that the Leader of the Opposition can make further submissions and clarifications on these particular issues. And then the committees can therefore formally report. If we allow them to just take note of these issues, we may lose track of the particular issues. It will also help us, Madam Speaker, follow up with your own plea to us. When we were passing some of the budgets in supplementary, I recall you made an undertaking and said, honorable members, please, let's do it for the last time, and we are going to follow up. And we listened to you, Madam Speaker, during that plea. So my issue is to request you to formally have these matters referred so that the committees can do a thorough job. And next time they come here for money, maybe we will not have that pulling of string, because issues would be clear that A, B, C, D has already been dealt with, Madam Speaker.
Doug?
Right Honourable Speaker, I'm seeking a clarification. While Honourable Dur is requesting that you formally make a referral of all the reports that the Right Honourable Leader of Opposition has presented before Parliament to the relevant committees. I'm sure myself and my colleagues in Parliament, we cannot offhand tell which reports he has presented because he has done this over time.
Let me help you in that one.
Yeah, I wanted to request that maybe we be given a list, we get to know which is which.
Let me help you in that one.
Thank you very much.
Honorable Leader of Opposition has been doing an oversight in most of this attack. They now inspire Rocco. Did you do Rocco? Yes. Leader of Opposition, I want to request you kindly to bring all those reports and lay them on table tomorrow, and we formally refer them for further action. Luboa doesn't have.
Honourable Speaker, you said that Luboa, we shall wait for your report and the Deputy Speaker. So I am thanked as official, but we are waiting for you. Honourable Speaker, I actually have laid all those reports before, but I will lay again tomorrow. I have no problem at all. We shall print again and we lay. Because you see, in the past, for each of those, you kept tasking government to come back and respond. And they have not. But just for the avoidance of doubt, tomorrow I will be here and I will lay again, right, Honourable Speaker?
Yes. Let it be a substantive item. Reports of oversight from the Leader of Opposition. Thank you. Next item.
Item 5 on the order paper. Motion for adoption of the report of the Committee on Rules, Privileges and Discipline on the review of the Rules of Procedure of Parliament.
Honourable members, you may recall that on Wednesday, 5th February 2025, the chairperson of Committee of Rules, Privileges and Discipline, Honourable Katuntu Abudu, presented a report of the committee on the review of the Rules of Procedure of Parliament. As you are aware, rules are always reviewed depending on the environment. The presiding officer deferred the debate to accord members adequate time to study the report. And I am convinced the 4 days have been sufficient enough for you to study the report and understand the report, and also understand the proposals that have been made by the committee. I now want to call upon the House I want to call upon the House. We open a debate on that. Yes, Ebualu.
Madam Speaker.
Honourable members, what you're going to debate is not going to form the changes in clauses. We will have to go to committee stage and look at a clause by clause and put your input in that clause. The debate is on the report, just like we always handle. Yes?
Madam Speaker, like you rightly put it, we had the 4 or 5 days to go through the report, and I would propose that we move straight to committee stage so that we can follow clause by clause in details. Yes. Yes. You wait. Wait. No, wait. Yes.
What has happened? They've given you the floor. Can I use your floor?
Honorable members, remember if you're going to debate the report, it's okay, but we shall limit now on the what? On the at committee stage. Is that what you want? Is that what you want?
Madam Speaker, the honorable colleagues did not understand me. It is at committee stage that we shall have sufficient time to discuss clause by clause. Because what's going to happen now, we are going into general debate, we shall not have sufficient time.
Is that seconded? Is that second? Honorable members, honorable members, I wish you could understand what Jonathan, not Jonah, Jonathan is saying. Jonah, you help your namesake. Jonah, help your namesake, being senior.
Thank you, Madam Speaker. My name was even mentioned in this report, and there's something that was said. Actually, the chair called me. You remember one time I raised the issue of the committee.
So what is the procedure matter?
That's what I want to raise, Madam Speaker. I raised the issue of the Committee on Human Rights coming to your opposition, and you directed this House that at one time you invited the leader of opposition, the Attorney General, Doug, and me, plus the Prime Minister, to see how we forge away what exercise should be carried, because I was saying that the Committee on Human Rights is an accountability committee. But incidentally, I was not invited to appear before the committee to give my position. And my good friend, Honorable Abdu, to whom I emulated to become a lawyer, he said he invited me. I said no. He said the leader of opposition was informed. I was not informed. And that component of the Human Rights Committee, I would pray, if possible, that it should be saved for that reason, because we did not appear to give our position, yet you are directed, Madam Speaker. And there are many issues I want to talk about Human Rights Committee being headed by the opposition.
Honorable members, I also want to instill discipline in us. If the matter is concerning somebody in opposition, you should discuss that matter with a leader of opposition, so that the leader of opposition is able to transmit it to his member or whichever. Yes, Honorable Abudu.
It is true. I would like to confirm that I called my friend, the Honorable Gozanga Seungu, complaining about remarks he had made to a radio station. Right, Honorable Speaker, and the record is clear. Before we began this process, I did direct the clerk to the committee to formally invite, one, the leader of government business, the government chief whip, all chairpersons of committees, the leader of opposition, the opposition chief whip, and all whips, plus all members of parliament, all, including Honorable Sewung, all of you, in writing, and all your documents were deposited in your pigeon holes. All, yes. Yes, because the first time we met, except the office of the clerk had responded, I directed the second time. And during the second time, I emphasized, actually, especially the office of the leader of opposition, the government chief whip, and the leader of government business, that they should actually even sign for it and prove to me that actually they had served. None of them replied. None. Twice. And we had adjourned the meetings twice because of non-response. Two, there are members who did, and that include the Honorable Dr. Lulume Vaiga, the Honorable Opendi, the Honorable Mavenjina, and I think we have put them in the report. They replied. They responded to the communication we did. So it is being disingenuous. It's not fair, especially when I hear things on radios and so on. I mean, together with my colleagues on the committee, try to act as professional as possible. We don't want to be dragged in unnecessary controversies, really. It is unfair. It is very unfair. Because we are conscious these rules are for everybody. Why would we sit in a committee and decide on them without your input? But you all kept quiet. And now you are complaining. It's not fair.
Thank you. Ajat, you're a member of the committee.
Yes, we are not debating the report, Right Honorable
Did
Speaker.
you present your minority?
I did, and that's the
Okay.
matter I want to talk about.
Okay.
Right Honorable Speaker, the matter of
But
the
you're very
leadership...
smart today.
Thank you so much, my Speaker. Right Honorable Speaker, the matter of the leadership of the Human Rights Committee is part of the report. I even made a disclaimer here that whereas I didn't report about it, I don't agree with the views on a minority report. Therefore, it's a subject of debate. We
Yes.
shall debate it, and whichever positions that the House
Exactly.
will like will take the day. So it's
Yes.
part of the report and is debatable.
Thank you, thank you. That Alebtong.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, this report we are talking about from Honorable Abdu Katuntu is a very bulky report. And most of us who are in the House would agree with me that we need sufficient time to go through it clause by clause. I therefore stand to second the motion from Honorable Jonathan Ebwalu that we move direct to the committee stage and have sufficient time. Thank you.
Thank you. Seconded, those who are seconding that we go to clause by clause for you to understand the changes. Yes. Huh? Honorable members, remember that the report is only informative. The report only informs you. But what is important is a clause by clause debate and the amendments that you're going to bring on clause by clause. Are we together? You want second?
Madam Speaker, I wish to respectively disagree with the motion because, Madam Speaker, the very reason why we want to be very careful at the committee stage is because, first of all, it is because these rules are very important.
Okay, you debate.
And
You debate. Debate. Go ahead and debate. And I'm giving only 5 people.
Thank you, Right Honorable Speaker. Right Honorable Speaker.
Don't listen to Linos.
Right Honorable Speaker, these rules are very important to this House. My question, first of all, is every House makes its own rules, for which I wanted to seek a procedural guidance. Every House makes its own rules, Madam Speaker. Madam Speaker, this House is entering its final year. The procedural matter I wanted to raise for guidance before I start the debate is whether this is not to preempt the 12th Parliament, because, Madam Speaker, we have entered the year of elections. Why don't we allow the rules of Parliament to be made by the 12th Parliament, and we proceed with our own rules, Madam Speaker? And that is
Honorable,
I was seeking for
as a senior in this House, you know that rules are amended at any one time when it deems fit. They are a living document that you need to refer on a day-to-day basis. When we got COVID, did we make an amendment on our rules? So there is no problem amending these rules. Even those who are coming back on 12th Parliament, like some of you, will amend. Yes, Ethel. Ethel Edakas.
Thank you so much, Madam Speaker, for allowing the debate. And right away, I go to the recommendation on page 38 about traditional wear. Madam Speaker, the committee recommended under Part 2 that the committee recommends that as follows: a pair of long trousers with a jacket, kanzu and jacket, safari suit and
that is which clause?
Under, we are looking at
which clause is that?
Under Rule 82.
That's what I was saying. You would reach there and look at it.
Madam
But
Speaker,
it's okay, go ahead.
Yes, I concede, and many of us here, as we go to that very point, we should note that we are not in agreement with removing traditional wear as part, removing it from our rules as part of our dressing. So let's get there. Please, in advance, note that we shall be against this recommendation. I also agree that we can go to committee stage.
There is a motion. Motion takes precedence. Motion? Okay.
Honorable Speaker, this might not be captured at committee stage, but I thought I would be guided a little bit. In the committee report, the Right Honorable Speaker directed the Committee on Rules, Privileges and Discipline to conduct a comprehensive review of the rules of procedure of Parliament, excluding Rules 7 and 8, and report back to the House within 2 months. Now, Rules 7 and 8 are to do with the powers of the Speaker. So I wanted to be guided. Powers of the Speaker entrenched that they cannot be revisited. I want to know the wisdom behind saying this should not be looked at, because who knows? Honorable Speaker, they could even have added new powers if you had allowed them to touch Rules 7 and 8, or perhaps balance things up and so on. But I just wanted to understand and get guided the reason behind saying, please don't touch Rules 7 and 8, which are to do with the powers of the Speaker. Because I thought none of the rules is entrenched. We can review, we can amend, we can make alterations as we deem fit on any of the rules. Thank you, Honorable Speaker.
Thank you. Motion?
Thank you very much, Madam Speaker. Madam Speaker, I move that we end the debate and then we go to the committee stage. Since right from the first submission, we are already moving on to what is supposed to be discussed at the committee stage. Madam Speaker, I beg to move.
Thank you. Is that seconded? Seconded by Apollo, Itungo, Rionga, Workers, Agnes, Alebtong, Lillian, Isaac, Thomas, Chikube, Dakas, Pesh, Elda, Annette, Atiang, Okorimo, Olanya, Linos, Kelly, Auma Kelly, Apollo, Nakasongola, Mbale City, Kodi, Namaingo, Emmanuel, Apache, Jonan, Soroti. There is Gwere, Soroti East. Honorable members, I now put a question that the report of the Committee of Rules, Privileges, and Discipline on the review of the rules of procedure of Parliament be adopted by this House. Those in favor say the contrary nay. The ayes have it.
Committee of the whole House. Rule 2.
Madam Chair, amendment of Rule 2, interpretation. Rule 2 is amended by 1. Deleting the definition of a cabinet, substituting for the definition of leader of government business the following. Leader of government business means the Prime Minister appointed under Article 108A of the Constitution. And 3, substituting for the definition of leader of the opposition the following. Leader of the opposition means the member of parliament who is the leader in parliament of the party in opposition to the government and having the greatest numerical strength in parliament. 4, substituting for the phrase leave of parliament or the house for the phrase leave of the house. 5, substituting for the definition of official report the following. Official report or Hansard is a record of parliamentary proceedings in text or audiovisual. 6, substituting for the phrase by order of parliament or the house the phrase order of the house. 7, substituting for the definition of precincts of the House or Parliament the following. Precincts of Parliament means the chamber and offices of Parliament and the galleries and places provided for the use or accommodation of strangers, members of public, and representatives of the press, and includes while Parliament is sitting and subject to any exception made by the direction of the Speaker, the entire building in which the Chamber of Parliament is situated, and any forecourt, yard, garden, enclosure, or open space adjoining or appertaining to that building and used or provided for the purpose of Parliament. 8, in the definition of question, by deleting the phrase and the question of privilege. 9, by substituting for the definition of the word whip the following. Whip means the government chief whip, chief opposition whip, and the party whip. 10, by inserting in the appropriate alphabetical order the following definitions. Dignified as prescribed under Rule 8.2, Official record includes the official report, audio-visual recording of the proceedings of the House or committees. Privilege means powers, privileges, and immunities enjoyed by the Parliament collectively and by members individually under the Parliament Powers and Privileges Act. Report of a committee means the report signed by the majority of the members of a committee, the minority report signed by members dissenting from the opinion of the majority, and members abstaining. Ruling means a decision by the Speaker on a matter of order, procedure, or privilege. Subsidiary legislation means any document by which a power conferred by any act or the President, Minister, or any other authority to make, or a power exercisable by making proclamations, rules, regulations, bylaws, statutory orders, or statutory instrument is exercised. Justification: to delete definitions that have not been used in the rules. 2, to improve, clarify, and align some definitions that have been used in the rules with the Constitution and other legal provisions. 3, to insert definitions that are necessary for better interpretation of the rules. Madam Chair, I would have begged to move, but ordinarily we handle the definition sections at the end. So I would pray as the colleagues think about it, we handle this particular one after we have concluded the process.
Thank you. We are starting over close. Rule 2.
Yes.
Rule 3.
Right Honourable Speaker, Rule 3 should be amended by substituting for sub-rule 4 the following. Where the oath of allegiance and the oath of a member is to be taken after the first sitting of Parliament, the Speaker shall administer the oath of allegiance and oath of the members in Parliament. Justification: to ensure that a member who joins Parliament after the first sitting takes both the oath of allegiance and the oath of a member of Parliament. Previously, it was not provided for under the rules.
Thank you. Aisha?
No objection for that particular.
Thank you. I put a question that Rule 3 be amended as proposed. Those in favor say and the control nay. The ayes have it.
Rule 9.
Right Honourable Speaker, we do propose that Rule 9 is amended in sub-rule 2 and 3 by inserting immediately after the word hand, the word side. 2, by inserting immediately after sub-rule 4 the following. Where the Speaker determines that it is not practicable to comply with the sitting arrangement, in sub-rule 2, 3, and 4, the Speaker may permit a member to sit on either side of the House. 4B, notwithstanding sub-rule 4A, the front row seats to the right-hand side of the Speaker shall be reserved for the lead of government business, government chief whip, and ministers. And B, left-hand side of the Speaker shall be reserved for the lead of the opposition, opposition chief whip, shadow cabinet, and party whips of any other party in the opposition. 3, by substituting for sub-rule 5 the following. The Speaker shall ensure that each member of Parliament has a comfortable seat, taking into consideration the age and physical disability of a member. 4, by inserting immediately after sub-rule 5 the following. 5A, notwithstanding sub-rule 4A, the Speaker shall ensure that the seats allocated to other members and members with physical disabilities are reserved for such members. Justification: to give the Speaker the discretion to allow the free seating whenever necessary, and also to cater for the seating arrangement of members with disabilities and older persons.
Aisha.
Thank you, Speaker. I have no problem with the allocating sitting area for older persons. The point of contention is offering free sitting to the whole of left. I was persuaded to give some space because we're a big number. If we restrict ourselves left on left and right on right, probably some people cannot get a seat. But the humble prayer is that at least 2 rows be reserved for the opposition. The minority needs to be protected. At least 2 rows, because the leadership in front needs people to speak to behind. It's not been usual that you'll find the opposition shift on the right-hand side. It's the people in government that shift on the left. But if we are to give in, we give in at least the rows.
Yes.
So the only difference, and I'm explaining because there hasn't been a debate so that people can follow through. The difference with my divergence is that I'm not suggesting that the whole parliament should be a free sitting. Colleagues say Speaker should restrict the front benches to the ministers on both sides. I am praying that we reserve 2, the front and the second one, so that leaders here have people to speak to when they turn behind. That's the prayer.
I think she's not asking for too much. No. Honorable members, Honorable Aisha is proposing that as opposition, the first floor and the second floor. Second floor. Now, in the circumstance, I wanted to ask a question. You're now talking about the third floor. I am talking about what Honorable Aisha is saying. Now, if you're saying up to the third floor, in the circumstance that you have space like the one you have between Honorable Abedi and Honorable Polot, can't one of your colleagues sit? No. Will you leave that space free? Will you leave that free?
Right, Honourable Speaker, that's similar to asking, you see on the front bench this side there's only 2 people. I don't know whether I can cross over and I go and sit there.
By the way, I agree with what Honorable Aisha is saying in totality.
So I wanted to actually suggest a slight amendment because she's talking about 1 and 2. But I want to suggest on both ends actually, aside from the front rows, that we count 1 and 2 because it helps when we are coordinating our, our operations, our debates, and so on. It helps a great deal when we are together. So also, I would not want a situation where the second row or third on the other side is filled by opposition people. Because, Honourable Speaker, some people can choose to say, okay, let's now do it that way. So you find even on the government side, on the second and the third, there is opposition people. So that's why I'm suggesting that aside from the front benches, 1 and 2 on both sides should be protected.
1 and 2.
Thank you very much.
But anyway, that is a simple thing, notwithstanding what the Speaker will pronounce. Yes.
Okay, maybe let me try to clarify, then members can speak from an informed position. Currently, what has been happening is that whenever they have declared free sitting, because of challenges of numbers, and I want you to know that, the issue is about the numbers. You'll find that many members, especially this side where the other side there are many, so there is an overflow. The overflow has been sometimes even on the front bench, on the opposition. And the innovation we are bringing is, even if there is an overflow,
Panadol.
and we are saying even if there is an overflow, both this bench on the opposition and the government side because of hierarchy of leadership in this house, should be reserved for those who are entitled to sit on it.
Yes.
That's number one.
Yes.
Number two, if you can listen. Number two, when do we declare a free sitting? Free sitting is because the seats are not enough and you have a challenge of numbers. So whenever you continue exempting more, you'll cause more crisis of members. What we are looking at is, let us respect the leadership of both sides. But the other seats can be available to all other members such that members can sit comfortably. That is the innovation.
Thank you. Yes, Honorable Angoda.
Thank you very much, Madam Speaker.
Venus.
Madam Speaker, last week when the Honorable Katuntu presented here, and the Honorable Aisha, in her minority, also presented to us who were here, we appreciated the well-thought position that came from the chair and also the Honorable Aisha. Those two, the front and the next one, provide an opportunity for sharing information. Many times when we are there, we also give some backup. Now, we cannot have the rest of the seats behind open, and yet we have members who are standing. So I think let's go by the position that Honorable Aisha has presented. We unanimously moved and adapted to it the other time. We can do the same again today. I thank you very much.
Thank you, Malebtong. Then, Naboth, I'm coming to you.
Thank you so much, Madam Chair. Madam Chair, the clarification I'm seeking, whereas I don't totally disagree with the proposal by Honorable Aisha, and I think it is very healthy, we've had scenarios where sometimes some members decide to abscond, they decide to walk away, and when there are very critical matters of national importance to be discussed. At times when we are sitting in other spaces, for example in Kololo, as a space for Parliament to sit, we've had scenarios where we were sitting at the regional sitting in Gulu, and the issues discussed or to be discussed are very pertinent. And we don't feel comfortable to leave the front rows empty. Therefore, I would like to agree with the proposal by the chair of the committee that based on the discretion of the speaker, when she finds it necessary, he or she, the speaker, can be the one to guide on free sitting. Thank you.
Honorable members, what Honorable Aisha is saying is not ring fencing per se. We are not ring fencing. When it depends on the circumstance. Like now you cannot come to the house, and because you have seen only Lop sitting, then Panadol is going there to sit, Macho, and yet you know very well that is supposed to be for opposition leaders. You get it? And from today, Macho, that's where you're going to be, Panadol, that's where you're going to be sitting. Stop. So, depending on the circumstance. So, for me, I don't really have a problem. Because if leader of opposition is sitting here, cow, they may want to consult. They may want to consult from behind, what do you think, and that kind of thing. Same thing here. That is that. Huh?
Can I suggest a way forward? Because the sort of thing we are discussing is important and so on. I was like been consulting my colleague. Let's concede to the two rows. I concede to the second row and proceed.
Thank you. I put a question that rule
Thank you. Madam Chair, I would like to be on the record.
Jana, let him first speak.
Thank you, Chair, Madam Chair. We are discussing and mentioning opposition and government side. Where does this leave the members of the independent?
Where are you seated?
But usually we also occupy That's it. Like government side, NRM, we usually sit
I am
where the
I am
opposition
the Dean of Independence. I will know where my independence. And the amendment does not take 9(1). Okay? Yes. Let's first hear from the minister.
Yeah, thank you, Right Honorable Speaker. I think in the amendment, the committee mentions physical disability. But we people who sit here are not all physical disability. We have a deaf representative. Because physical disability, according to our act, is somebody caused by cerebral palsy, amputation of a limb, and paralysis or deformity. So we need to look at whatever it is in the...
There's also Panadol who has no eye.
He also has a definition here. Even the Panadol with the partial disabilities on the law. So let us recognize that it's persons with disabilities who are members of parliament of this house, so that you don't have words which are discriminating others. Thank you.
Yes. Honorable Katund.
I concede. For Honorable Mugema's purpose, I concede.
Jonah?
Yeah, Madam Chair, I wanted to go on the record that I actually oppose the amendment entirely for the reasons that the sitting in Parliament is not just a mere rule. It draws from the recognition that there is democracy and two sides in the
Left
House.
and right.
And Chair, Parliament, as you know, there are also occasions where there are tensions may arise out of the subject matter at hand. The separation or proposed, including the demarcations that you recently ordered, speaks to that spirit, that this is a house of two sides, and there may be situations that may need physical barriers. And that's why, Madam Speaker, first you protected yourself there, and then you have put these barriers here. That recognition should not be swept aside. I also want to say that some of the proposals are actually redundant, because the rules as it is, I can read sub-rule 4. The Speaker shall reserve seats for independent members of Parliament and other categories of members. What are those other categories of members? Oh, exactly. So, to again say that reserve for older persons, reserve for this, what if next time we have another category coming into this other Parliament? We cannot list them. So by saying other categories, I feel every other situation has been taken care of. Madam Speaker, lastly, if this amendment is to go through, because I want to say that I want to propose that we insert where you, Madam Speaker, or the presiding officer consults the two whips. It would be courteous that before such a decision is made, that there is free sitting, there is consultation. Because, and this is in good spirit, Madam Speaker. I know the House has been trying to fight that we must be together. We are together, but let's recognize the pillar of democracy, Madam Speaker.
Madam Chair, I wish to respond to my brother's submission. One, just imagine a situation where you have a house and you only have 10 MPs. This particular house, in the entire house, this side, and the rest are the other side. How are you going to govern it?
Clarification.
Two, the Speaker has been invoking what we call general powers. She has. What this rule is providing are specific powers of the Speaker in regarding to the issue of sitting. It can't be redundant, because the Speaker wasn't empowered other than using the general powers she has for members to be comfortable. And don't allow that sort of situation, because chances that whenever the time is even had faith, but here he will be you want to inform me on the rules? Really? Okay.
You see, thank you, senior member, for giving way. Madam Chair, as members of parliament, we are mandated to be here whenever there is a sitting. And it's only on rare occasions where a member maybe is indisposed, and the speaker must be in know of your absence. So what I want to inform the honorable member, whether there are 10 members seated on this side, and the other side has 100, business can continue. We've been in this house where the opposition say we shall not be in this sitting. Once we move out, the speaker rule says, no, members, some of you come and sit where you want, where the opposition has been, and the house goes on. So what am I saying? Is that the Speaker of Parliament has all the powers to determine our seating arrangement. But following the rules, because already this house has two sides, the ruling government and the opposition. So when you look at the independence, so I don't see, no, you can correct me, because what you talked about, the numbers 10 on this side, wouldn't arise. Whether we are 10 and the other side is a bigger, it can still remain as the rule has been. That's what I want to inform you. Honorable
Aisha.
Right Honorable Chair, allow me inform Honorable Jonathan and colleagues that this report is alive to the fact that we are in a democracy, and we subscribe to the Commonwealth countries that have a sitting arrangement in Parliament. And the report recognizes that the members in the ruling party will be on the right-hand side, and the members on the opposition will be on the left-hand side. This report recognizes that, but it also recognizes that there are exceptional circumstances. So now we are talking about those exceptional circumstances where the speaker has already said free sitting. So what the major report was saying, the free sitting should exclude, whatever the circumstance would be, should exclude the front. Now he has conceded to the fact that the free sitting, whatever the circumstance may be, should exclude two benches on the front side of the opposition. Right, Honorable Speaker, it is also okay for the public to see that their members of parliament are not there. If the seats are empty, let people know that members of parliament either have walked out or have absconded from duty. So it's okay.
Thank you.
Will you allow me read the amendment as proposed?
The amendment?
Yes.
You read the amendment. I don't know what.
Right, Honorable Speaker, the colleague have conceded. I therefore
Madam Chair.
Move.
Eki. How do you access the microphone? Aisha, can you read?
I therefore move that Rule 9 is amended by inserting immediately after sub-rule 4 the following. 4A, where the Speaker determines that it is not practicable to comply with the sitting arrangement in sub-rule 2, 3, and 4, the Speaker may permit a member to sit on either side of the Speaker. 4B, notwithstanding sub-rule 4A, the Speaker shall reserve the front rows to the right and left-hand sides of the Speaker for the ministers and shadow ministers respectively, and the second row on the left-hand side of the Speaker for members of the opposition parties in the House. Justification is to give the Speaker discretion to allow free sitting whenever necessary. 2, to reserve the front seats on either sides of the Speaker for ministers and shadow ministers. 3, to reserve the second row seats on the left-hand side of the Speaker for the opposition purposes for consultation purposes. Thank you.
Thank you so much. And then the amendment of Honorable Samuel to...
Yeah. Right Honorable Speaker, I considered after listening to my...
Thank you. So we are taking with amendment of Honorable Aisha and Honorable Samuel. And that also happens. I now put a question that Rule 9 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Rule 11.
Rule 11 is amended by substituting for sub-rule 4 the following. Nomination of the candidates for election to the commission of the 4 members of parliament referred to in sub-rule 1F shall be made by the government and the opposition sides in accordance with the rules set out in Appendix BA. Justification: to provide for detailed procedure for nomination and elections of the 4 commissioners to the Parliamentary Commission, which is not provided for in the rules.
Continue.
Right Honourable Speaker, the justification has been that whereas the parent act had provided for election of the members of the commission, the practice has been designation. And then the rules had introduced the word designation, which is contrary to the parent act. So we are trying to streamline our rules in accordance with the administration of the Parliament Act, which provides for the election of commissioners.
Thank you. Aisha? 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 Aisha?
Thank you, Chair. There is no disagreement on the proposal.
I put a question that Rule 11 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Rule 13.
You had all the time. You had all the time to go to the committee. Proceed on what?
Thank you very much, Madam Chair. Madam Chair, before we moved to committee, you guided that when we are at committee stage, members will be able to debate and discuss.
So
it was your ruling, Madam Chair. And it's basically that's what we are trying to follow, that you grant us opportunity to debate at each clause at committee level.
We are proceeding really very well. Abudu, go the next.
Procedure, Madam Speaker.
Procedure on, under which rule? 8 is... Madam Teacher.
Right, Honourable Speaker, I'm proceeding under a rule that talks about your general powers as a Speaker. Right, Honourable Speaker, the procedure issue I wanted to raise was to seek your guidance under your wide powers to be clarified. You have just ruled here that we have passed the clause, but we have commissioners in this House right now.
4.
And I understand that, and I was trying to consult Honorable Katun here to know if what I understand is proper, that we cannot make rules that act backward.
Yes. Retrospective.
Indeed. Now, right, Honorable Speaker, now that we have commissioners and we make this rule, and you have guided when I raised the matter about the fact that this might have been work for the next parliament, you said indeed we still need to make rules for this parliament. Does it mean that now that we have that rule, we are going to get new commissioners, or are making this for the future? And are we supposed to legislate for the next parliament, Madam Speaker? I want to be clarified.
These amendments shall not have retrospective effect. So the commissioners, as currently constituted, were elected in accordance to the rules as they were then. But tomorrow, the vacancy can fall, either by an act of nature, or by which could be that one I don't want to talk about, or resignation, or even for whatever reason. Then that commissioner, a new incoming commissioner, why don't I explain first? Then that incoming commissioner will be elected in accordance with the rules as we pass them. So we are not first of all, to lose the position of the commissioner, you must do so in accordance with the rules and the act. As of now, none of those commissioners have violated any of the provision to lose the seat.
Owekitiibwa. Owekitiibwa.
Thank you. Chair, I wanted to ask clarification from the Chair of Rules. Except for adding the word that the election will take place in accordance with appendix proposed under BA, sub-rule 4 of the rules, they have replicated the same. If we can read together, the rule as it is now says nomination of candidates for election to the commission of the 4 members of parliament referred in sub-rule 1F shall be made by the government and opposition sides. The committee has just added, they just added that it will be in accordance with appendix. So the clarification I wanted from the chair of the rules, he says that an election took place in accordance with these rules, the current rules. The clarification I wanted from him to brief us, when did this parliament sit to elect the commissioners?
I said in the current rules, we were using the word designation. You get it? 2, to understand this amendment, you have to read it together with now what is provided for on page 118, appendix BA, because now it gives the detailed procedure of election, which did not exist. Which did not exist. And in our view, you need to read now appendix BA, which introduced a very different method of elections, such that you satisfy both the Administration of Parliaments Act and anything to do with the designation as it has been. It can't be in the case that office falls vacant tomorrow.
Do you have the procedure in the old rules? It is not there. So they are only introducing, and they are saying within 2 days of the first sitting, of the first meeting of the first session of Parliament, that is when we should have the election take place. Yes. And this is in conformity with the Administration of Parliament Act. You have something
Chair.
contrary?
Chair, I think to facilitate debate of this particular rule, would be procedure right for us now to discuss the procedure, because whether commissioners would be elected or not, it wasn't a matter of contention. The law actually required us to have elected commissioners.
Yes.
Now, how are they elected would be the issue. If it pleases your chair, you would take us to that particular appendix at this time so that people agree with the appendix or make possible amendments to it.
You see, Madam Chair, I pray that we don't create a situation where we are as if preparing rules for the next house in anticipation of our being there, if God it makes us be there. Unless we are stating it expressly here, that those clauses breathe after that Parliament coming. Because after swearing off in the Speaker, the Parliament makes its own rules. So the moment we tamper and give procedures with the election of commissioners, that means we are preparing rules for the next house, which we are not sure of being there. All by my rosary, I will be there, you never know. And prayers, no, there's nobody who is assured of that. It's God, it's your personal chi that's going to help. Madam Chair, I think we have to take keen interest in that. Otherwise, we cannot prepare rules for the next Parliament.
Chair, take us through the procedure. Appendix B. BA. Honorable
All-
members,
Okay.
you cannot expect new members to come and start sitting and making rules. Even the rules we are using were made by people who were not here. Yes. Unless if you're, most of us, you know very well. You go ahead.
Madam Chair, election rules, election law is always about the future, not the past. You cannot enact a law on elections in the past. It's about election which is going to happen in the future. Other than having a debate like we used to have some time when we are down. So what we are looking at currently, one, what we are looking at, I am already taking any clarification. I don't want anybody to imagine there is a big question which.
Thank you very much, Madam Chair. Honorable Budu, you are the one who has been mentoring us, saying that we don't legislate in anticipation. Now it seems you are now taking us to anticipate, because the Commonwealth practice, the foundation upon our rules are prepared. Every parliament makes this rule. We can adopt the rule. If a new parliament comes, they can decide to adopt that rule or make its own rule. So I want to seek clarification from you. That is it proper for you to be on record to make statement in anticipation that the next parliament, this rule we are making for them so that it will help them to conduct election, their first sitting.
Rule 13. Honorable Budu, Rule 13.
Colleagues.
Rule 13.
Yes. Rule 13.
I did. We are finished.
I'm just going back to Rule 13. As I go back, honorable colleagues, we did not have election and now we are providing for election. Really, that's the essence. Rule 13 is amended.
But if you want. Honorable members, I think members didn't hear the question. I put a question that Rule 11 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Rule 13.
Rule 13. Amendment of Rule 13. We propose amendment of Rule 13 by inserting immediate after Sub-Rule 1 the following. Subject to Sub-Rule 1, at least one of the members of the Pan-African Parliament shall be a woman. At least. Right Honourable Speaker, we are aligning with Article 4.2 of the protocol to the treaty establishing the Pan-African Parliament community relating to the Pan-African Parliament, which requires that one of the 5 members shall be a woman. It's not like this is independent. We are just aligning our rules to the treaty establishing the Pan-African Parliament.
Honorable members, that was not existing in the original rules, and it is in alignment with the Constitution and then the treaty. Aisha? Aisha?
I agree with the majority report.
Yeah, Madam Chair, before you put a question, I wanted to propose an amendment.
Yes.
To Rule 13.
Yes.
To read as follows. A member elected to Pan-African Parliament shall relinquish any other position, or a member elected to Pan-African Parliament shall not hold any other position in Parliament. This will allow the member not to hold two concurrent, like currently the chair of rules is also a member of the Pan-African Parliament.
Honorable members, yeah, it is a good one. You cannot be in Pan-Africa and you are in the chair of the committee.
Right Honourable Speaker, I concede.
You concede?
Yes.
Right Honourable Chair. Right Honourable Chair. I think Honourable Dole must have noticed that the chair was giving a lot of time to the deputy chair to do a good job. So it's good he has conceded because his deputy chair was doing a good job as well.
You have considered?
Chair.
Honorable members, I put a question that Rule 13 be amended as proposed with amendment. Those in favor say on the contrary, nay. The ayes have it.
New rule.
The new... No, he has not resigned.
Well,
he has a dean who will...
I can say the rules don't have retrospective effect. And I think we have already explained that to the honorable members. Rule 5. We are now rule 14.
14?
I think
there's a new rule?
Yes. The rules are amended by starting immediately before Rule 14 the following. Role and functions of lead of government business. There shall be in Parliament a lead of government business designated as such by the President, who shall be responsible for the coordination and implementation of government policies across ministries, departments, and other public institutions. 2, the lead of government business shall perform such other functions as provided under the rules. Justification to provide for the role of the lead of government business in the rules. Colleagues, as you realize, whereas the role and functions of the leader of opposition is provided for in the rules were cited on the role and functions of the leader of government business. So we are now just transplanting them as they are in the Constitution. The role we are giving here are those which are provided for in the Constitution, like those which are in the rules for the leader of opposition were also transplanted from the Constitution.
Yes.
Madam Chair, I want to thank the Chair. Let him come out straight on this new rule. Because what we have in our rules or in the Constitution is the Prime Minister being the lead of government business. Are we creating a new position? And if it is, if not, I would wish seeing this new insertion talking specifically the Prime Minister as being the lead of government business. Otherwise, if we are creating something new, we are going to have a challenge between the Prime Minister and the new lead of government business. Could we understand what you exactly mean on this? Because the lead of government business by our Constitution is the Prime Minister.
Honorable Katuntu, isn't this really redundant?
No, it isn't. Actually, I wish you had read the amendment. Have you? It is saying, there shall be in Parliament a leader of government business. It is there because that's what the Constitution provides. Designated such by the President.
Yes,
that's what the Constitution provides. Who shall be responsible for coordination and implementation of government policies across ministry, department, and other public institutions. I am scratching my head to see the controversy.
You know, Honorable Abudu, who shall be responsible for coordination, implementation of government policies across ministries, departments, and other public institutions? That is from executive, not legislature. Let your neighbor explain to you. That is from executive, not legislature. It is defined by the executive. We are legislating on what we do day to day in Parliament. Now, this is what executive has tasked or chosen, given to who? The leader of government business.
You see,
and then the leader of government business shall perform such functions as provided under the rules. But this is what the president has designated.
The one which was designated is under 1.
Even 2.
Huh? No. The what has designated is lead of government business. That actually it is not even the president. The constitution designates the leader of government business to be the prime minister. Then who shall be responsible for coordinating and implementing of government policies across the ministries within within Parliament?
Chair.
And that's the prime minister.
The prime minister, yes.
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 Who is the head of government business? I don't know whether I understand you.
Her roles are defined by executive.
Chair.
Her roles are defined by executive.
No, you see.
Chair.
You know, let's not go into, let's not clash.
Yes, Chair. Chair, from that amendment, it presupposes that the president can appoint another lead of government business apart from the prime minister. And that is very dangerous for us to put that in our rules. The law is very clear, the constitution is very clear that the prime minister is the leader of government business in Parliament. And we don't need to provide for it in our rules.
Under the Constitution 108A, the Prime Minister shall be the leader of government business in the Parliament and be responsible for coordination, implementation of government policies across ministries, departments, and other public institutions, and perform such other functions as may be assigned to him or her by the president. By the president. As may be conferred on him or her by the Constitution of Uganda.
Chair.
Yes.
What Honorable Wanika is very fearful of is taken care of under the definition. In the definition, the leader of government business is defined as a prime minister. So we cannot have another office created. But the role of government business in Parliament is not stipulated in the rules as of now. So the committee was prudent to get the role of the leader of government business to be stipulated in the rules and define who is of government business as a prime minister.
Madam Chair, I think, let me,
Yes.
I'm asking the Chair, Madam Chair, through you to the Chair, there's no problem by making a transplant. We can expressly state it and include the word Prime Minister in the new insertion so that it sits in our rules comfortably. But the moment you don't put it there, in our rules we create offices. And
No, the rules exist to operationalize the laws.
Yes.
But we should be restrain ourselves to to legislature. Honorable Dur.
Yeah.
Yeah.
Yeah, Madam Chair, my understanding of the rules of procedure of Parliament is that it is only applicable when Parliament is in motion. That when you are seated there to guide our rules how we conduct business within this building, anything in the rules that purports to prescribe things outside would not be in the spirit. I therefore, and I'd already noted that I would oppose that amendment, because one, we will be dictating to the president, the executive, on what his or her appointee should be doing, which is not our work. If we intend to extract some roles that are limited within parliamentary business, for example, leader of government business, who is the prime minister, shall be the one answering during prime minister's question. That is something else. We should be explicit, but to lift from the constitution as it is, because the prime minister has responsibilities in the executive, but also here. Yeah.
Honorable Katuntu.
I still am not convinced. And let me tell you why I'm not convinced. Does the Constitution provide for the function and roles of a leader of opposition? Have we transplanted those roles from the Constitution to our rules? Have you read it? You see, yes, just look at it. Just look at whether we have translated the roles given by the Constitution to the leader of opposition, and we have also provided for in our rules. What we are trying to do, and if you can listen, what we are trying to do is exactly to do the same. What you've already done for the office of leader of opposition, and we are doing it for the office of government business. And when you look at the new rule, it is not inserting anything outside what is provided for.
Yes.
But if you are not comfortable, we can leave it.
Not we being comfortable, but less separation of powers. And as the Honorable Duru said, when the House is on motion, what is expected of? Yes?
Thank you so much, Madam Chair. Madam Chair, I stand to support Honorable Katuntu in that, marrying with what Honorable Jonathan has stated, the leader of government business is a member who sits in this parliament. And when you look into our rules of procedure and even the Constitution, all of us have been mentioned. Call it the leader of government, the chief whip, the members, and everybody else. So for me, I'm of the proposal that we stand over this, and then the chair, Honorable Katuntu, sits down and not only lifts from the Constitution, but comes with a clear proposal of how we are going to govern the leader of government business when we are seated and when Parliament is on operations. Because it should come very clearly.
You want to govern the leader of government business?
Madam Chair, with our rules of procedure...
No, I am saying you need to govern the leader of government business.
Madam Chair, let me withdraw that word. Madam Chair, let me withdraw that word. But how the leader of government business is going to operate, for me, I feel should come out very clearly on our rules of procedure. Thank you.
Honourable members, honourable members, can we stand over this?
Actually, if the House is uncomfortable, we can leave it out. If you think we can leave it out, and then you have a leader of government business whose role are not provided for under our rules.
Honorable Abudu.
Can we go?
Honorable Abudu.
I concede.
You concede? Okay. What are we cheering? No, I want to ask what are we querying?
Rule
I
15.
concede.
Okay.
I concede.
Thank you.
Rule 15.
Rule 15. 15.
Introduce also the leader of opposition, that there will be a leader of opposition in parliament, that we are doing. It's not, they
It
only
is
show
on-
roles. They don't show anything as far as there will be anything. They only start with roles.
Article 82A, leader of opposition.
What about including it in our rules? The way we've introduced whips, the way we've introduced leader of government business, there is need also to introduce the leader of opposition. We start by saying the roles will be this and that. We don't see. Look at the whips. We introduce whips that there will be whips.
Okay, look at Rule 14.
We start by showing the roles. We don't
I'm
introduce-
saying look at Rule 14. Role and function of leader of opposition. Rule 14.
You don't introduce. Let me just consider, but you don't.
No, you look at Rule 14. Read it.
Madam Chair, under Rule 14, we give the function of the leader of opposition. We say the principal role of the leader of opposition is to keep the government in check. I would have suggested the way we've introduced that there will be whips, we would also introduce that there will be a leader of opposition, and then we mention the rule.
Check the constitution, which is prim.
Thank you.
Honorable Katuntu. Next item. Next.
Rule
block.
15.
Rule 15. Rule 15 is substituted for the following. There shall be in Parliament a government chief whip appointed by government from among members of Parliament representing the ruling party, a chief opposition whip appointed by the party in opposition to government having the greatest numerical strength among opposition parties in Parliament, party whips for any other party in opposition. The role and functions of the whip are to ensure that members attend, participate in proceedings and vote in Parliament, organize party business, keep members informed of parliamentary business, supply lists of members to serve on standing and sectoral committees, coordinate and implement agreed parliamentary business, act as intermediaries between leaders and other party members, arrange representations of party members on official parliamentary delegations, and act as tellers during divisions. Justification: to consolidate the functions of the whips under one sub-rule for clarity and ease of reference. Right Honourable Chair, colleagues, the function and roles were spread, so we've just consolidated them in one rule and went ahead to, I think, assign some other functions which ordinarily should be the functions of the whips.
Thank you. Aisha?
I agree with the proposal.
I put a question that Rule 15 be amended.
Madam Chair, I wanted to use the opportunity to correct an anomaly under proposal 2B, organized party business, to add the word party business in Parliament. The responsibility of organizing party business is with the Secretary General. So when you leave it to organize
Party business in
open
Parliament.
here, we add the word in Parliament.
In Parliament. Chairman? Let's first sort out one thing at a go.
These rules govern according to Honorable Du. He was a few minutes here saying these rules govern only internal workings in the Parliament.
No.
So they
For
cannot
clarity.
go and apply outside Parliament.
No, for clarity.
But yeah, just come. But anyway, that notwithstanding, now that he has come to the position I concede.
Thank you.
He
Thank
has
you.
only moved from his
Thank
other
you.
position.
Yes. Yes.
Chair, I'm also proposing, in the last parliament, there was an interest of having vice chief whips. I mean deputy. And even
In the
this
last parliament, you're there.
I was following, right,
Okay.
Honorable Speaker. For the NRM side, I was following. And now, in this one, the opposition also had interest in having it.
We only have whips. Our rules only provide for whips. If the other one is administrative, you can plan according to what you want.
We could propose it at this
No, we are not proposing. I put a question that Rule 15 be amended as proposed. Those in favor say on the contrary. With amendment from Honorable Dul, those in favor say on the contrary, nay. The ayes have it.
Rule 16.
16. Rule 16.
Amendment of Rule 16.
Rule 16.
Rule 16 is substituted for the following. A member may, with the consent of the Speaker, move that
just administrative. It's very, very important. That's why we say quorum shall be determined at voice taking, rather vote taking. And vote taking includes aye and nay, where people cannot be heard to pronounce their decision of a matter. They cannot be considered to be part of the quorum. It's very important, and it cannot be simply taken to be administrative.
Madam Chair. Madam Chair.
Honorable Aisha, we are looking at you're looking at two issues. You're looking at quorum and voting. Is that correct?
Particularly here, yes. We have to look at the two together because
no.
Quorum.
You look at Rule 93. Rule 93 is a question to be decided by the majority. And here you're saying, except as otherwise prescribed by the Constitution or any law consistent with the Constitution, all questions proposed for decision of Parliament shall be determined by the majority of votes of members present and voting.
Right, Honorable Speaker.
Then you go to 3, the proxy form shall be submitted to the clerk within 12 hours before the commencement of the sitting to which it relates.
Right, Honorable Chair. Quorum is determined at vote. And my assertion is that you cannot be present, you cannot be considered to be a part of a decision when you cannot vote. And we are told by the technical people that people in virtual attendance cannot vote where we say aye and nay. And therefore, people in virtual attendance cannot be part of the quorum. It is just simple like that.
Chair.
They cannot be part of the quorum because they can't be heard.
Chair.
Let us put records correct. I remember very well in the 10th Parliament, members were debating online.
Yes.
If you can debate online, you can as well vote online. That's the reason we have this.
When we're voting for the famous LGBTQ,
yes,
members voted online.
Yeah, so with the modern technology, we cannot restrict ourselves by putting such. So I pray that we sustain it as it is. Otherwise, we can vote online as we debate online.
Chair.
That can only be seen by the presiding officer.
Chair, that's another point of contention. That's another point of contention.
So
Chair.
what is your view?
It's okay people to attend in virtual attendance. Honorable, I wish Honorable Seungu can listen. The situations is referring to people were voting through roll call. And I'm saying, in cases where decision is made through voice voting, people in virtual attendance cannot be part of the quorum because they can't be heard.
Chair.
And let me tell you,
Information,
Chair.
Right Honourable.
Chair.
Information.
Chair.
You first hear from another person, yes?
Chair, the honorable member is talking about quorum. You don't determine quorum by saying nay or aye. These are numbers. There is a difference between quorum and voting.
That's what I said.
Yes. The way it is, quorum can be determined.
Honorable
You
Connie.
don't need to.
Come and sit. Honorable Connie.
Thank you, Right Honorable Chair. Right Honorable Chair, like Honorable Wanika has said, a quorum is different from voting. And there is no guarantee that everybody votes because there are those who abstain. And therefore, it's still valid that by voice, there are those who will speak softly and those who will speak loudly. But the highest will be the one that will take that day.
Thank you.
Thank you.
Honorable members, I want to refer you to 24(6). For avoidance of doubt, a member virtually present in the House shall form part of the quorum of the House. We are talking about quorum, not voting. Yes, Jonathan.
Madam Chair, I propose that when we come to the rules on voting,
93.
you can give audience to
Yes.
Honorable Aisha to deal with that.
Yes.
Yeah, thank you.
Honorable Aisha, when we come to rules on voting in 93, then we can incorporate your matter.
You see, they allowed us this, honorable members, and we must exhaust the matter extensively. In this House, there are ex-officials. When you ask a question here on the floor, if you want to go by what Honorable Aisha is saying, it means that whenever you're going to ask a voice, ex-officials must get out. Because you are going to say the ayes, what? So, but what I'm saying is that the rules are very clear. Where the members are not satisfied, 40 members remain standing.
Thank you.
Challenge.
25.
Rule 25.
Chair, before you go on 25, actually the rule that you read is the one that I'm seeking to amend, because I'm suggesting or proposing that we amend.
We shall amend when we reach to that rule. We have not yet reached there.
You are skipping 24. It is saying, for avoidance of doubt, a member virtually present in the House shall only form part of the quorum of the House where voting is by roll call and tally, by show of hands, or by electronic voting. Because that's only when he can form of the part of the quorum. Otherwise, he cannot be part of the quorum because he cannot be determined his decision. So that's the point, that's the very rule that I seek to amend. Honorable friends, let me remind you that severally here, we have a number that is small, which is complemented by people in in virtual attendance, like there are 175, so quorum is there as we start to debate. In the process, when you're deciding issues, they put question and say aye, aye. It's only people here saying aye. The majority in virtual attendance are not heard, and yet we determined them to be part of quorum in the beginning.
Yes.
So
Linus.
Oh, thank you, Right Honorable. Like you mentioned, that you're the speaker is privileged to witnessing what is happening virtually. So if these members say aye, the privilege is only the speaker. The speaker listens to their voice. Yes.
No, the voting is always by the members who are in the House.
In the House, yes.
The voice voting.
Yes.
But what we are
you keep
saying,
following
we
it.
have also never had a scenario where virtually the members are more than those in the House.
Yes.
Let's not really.
Madam Speaker, Madam Chair.
Yes.
I think the honorable member has missed a point when she loads it over to you, when he knows very well that your lieutenants are the whips, especially in the determination of quorum. And it has become extremely difficult, almost next to impossibility, for whips, whose role is supposed to ensure due attendance and also determine quorum for you on your behalf virtually. It could easily be abused if it is not
just a minute before you proceed. Very soon most of you are going to be away. And we'll have bills to pass, we'll have appropriation, we'll have what? And you are the first people to say, we're in the constituency. I will be online. Do you want Parliament to stop running because of quorum? You get it, eh? Because quorum, we are looking at a number. We need a number. But all of you are going to run away. The heat is going to be too much down there that everybody is going to be out. Yeah?
Thank you, Chair. Right Honorable Chair, I've listened to the Honorable Aisha Kavanda. There is a logic, or there was, when they were drafting, and these two were put separate. Quorum is quorum, and Rule 93 that concerns voting is also independent and explicit. The rule we are talking about talks about
quorum.
And rules could not have meant to disenfranchise. It is all about 93.
Yes.
93 even provides for a member who is on leave, without leave of absence, to even have a member vote for him or her. But this particular one
that's called
talks
proxy
about
voting.
Quorum. Quorum. Thank you.
Moses, just let him speak then.
Honorable Chair, on the virtual voting, I think we have been having incidences where members who are not in the house, they vote by the show of hands, meaning that if somebody is on virtual voting or presence, then he can show by showing the hand that really I'm either accepting or I'm refusing. So it can be done in that way. Right, Honorable Chair.
Thank you. Hello. I'm coming.
Honorable Speaker, I want to disagree with colleagues who are disconnecting quorum from voting. That's not what the rules are saying. Rule 24, quorum of Parliament, sub-rule 1. The quorum of Parliament shall be 1/3 of all members of Parliament entitled to vote. Sub-rule 2, the quorum prescribed under sub-rule 1 shall only be required at a time when Parliament is voting on any question. There is, even without it, by the way, being in the rules, it ought to be implied. Quorum is only when you are going to vote on a matter. That's when it becomes critical. Otherwise, discussing and so on, even in our committees, you can discuss even if you're whatever bare minimum, yeah? But it's critical when it comes to voting. So it is not true that there is quorum on one hand and then there is voting on the other hand. Otherwise, what is it quorum for? Sub-rule 2 here is making it explicitly clear. The quorum prescribed under sub-rule 1 shall only be required at a time when Parliament is voting on any question. So then, we must be able to guide the quorum that is with us virtually, because it is required for voting purposes. Honorable Speaker, assuming we are 100 of us in here, and there's 100 online, virtually, we have quorum, for starters. But when it comes to voting, you cannot say only the 100 in here are voting, because then it is not 1/3 who are voting. It is much less. So we've got to answer that question, and that's why it becomes complex. So do the ones online vote aye, nay? How do we hear it? But like Honorable Aisha is saying, we must be able to guide it within the rules, because what's clear is quorum is numbers that ought to be able to vote. That's very clear here.
Chair, what is your position? Just a minute.
Right Honorable Speaker, we heard all these arguments, and I wanted to listen more if there is anybody raising any argument which I have not heard so far. So I'm trying to, because it was really very contentious, let me try to continue listening.
Honorable
if there
Goli.
is any new argument.
Honorable Seno.
Thank you very much.
Any doctor?
First to the chair of the committee. Do we define the word quorum in this document? If we define it, then it would give us guidance. Secondly, I would think that we need to separate this issue of quorum for voting and normal quorum, so that if it is possible, can we isolate all the related issues, articles related to voting, and we send them to 94? 93, so that we remove 24.2, 24.3, and send them to 93. If the definitions are different, so that we handle them differently.
Anthony? Anthony? I am coming.
Thank you, Madam Chair. When I listened to Honorable Aisha's submission, I was seeing the point she was making because of the voting issue, and I had sympathy with it. But Madam Chair, when you look at, when you go ahead and look at Rule 96, subsection 3, it's on the voting in the House. It says as following, in, one says that, subject to Rule 95, every member in the House at the time of voting shall cast a vote. The voting in the House shall be by A, voice voting, B, secret voting, C, electronic voting, D, division, E, roll call, which Aisha is talking about, and then finally by show of hands. But sub-rule 3 covers Aisha's concerns. It says, the Speaker may, where necessary, designate a specific voting method for a member virtually present in the House, where the member is unable to vote through any of the voting methods specified under sub-rule 2. So, Madam Chair, in my view, the concerns of my sister are covered because you have the leeway to decide how the virtually present members can vote in case they can't vote by voice.
Thank you. Doctor?
Thank you, Madam Chair. Madam Chair, I want to agree with my brother Anthony, the Honorable Anthony Seno. But to add that maybe if it doesn't cause harm, Madam, we would at this time expressly state that in the case of voice voting, which is aye or nay, those attending virtually will vote electronically, so that there is an intermarriage whereby we are catering in totality for all those in attendance, because those in attendance include those in the House and virtually. So we would make that amendment, Honorable Chairperson, to provide for ayes and nays for those present here, but we quickly intermarry it with electronic voting. I so propose. Thank you.
Thank you very much, Madam Chair.
Yes.
And I would like to thank the colleagues. The debate we are having now is actually the debate we went through in the committee. All these arguments, we had all of them. We differed on the interpretation of 96.3. That's where our interpretation was. To the majority, we thought that 96.3 provided a cure for the mischief the Honorable Kavanda was fearing. And this is what it says. The Speaker may, where necessary, designate a specific voting method for a member virtually present, meaning that members virtually present may have a challenge in voting. in the House where the member is unable to vote through any of the voting methods specified in sub-rule 2. And one of those specified methods is voice voting. And our interpretation is to cure that mischief, the Honorable Kaba, because what she's saying is actually we all agree that people who are not here may have a challenge to vote. But that's why we have Rule 96(3). And to us, we didn't see any reason for the amendment. We thought the Speaker just invokes this particular rule and says, yes, I've heard this, but this one, let me count. How many are they? There are 5. How do they vote? Then the ruling is made. That was our interpretation, and we didn't see the necessity for the amendment.
Thank you.
Right, Honorable Speaker, I have attentively listened to colleagues, and I want to allay their fears that this amendment puts into perspective the Rule 90, the one for voting. It just puts into perspective by saying, because the amendment reads, for avoidance of doubt. So we have noted that the Speaker can put an arrangement for members in virtual attendance to vote. We have noted that. So I'm simply saying, for avoidance of doubt, a member virtually present in the House shall only form part of the quorum if the Speaker puts into place that arrangement. So it reads, for avoidance of doubt, a member virtually present...
Honorable Aisha, I don't want people to run away from their responsibility when there is a contentious issue here. Let people be there to vote so that they don't hide away. Let them attend, let them come and vote. If we are voting for Tojikwatako, let it be. Let them let people not hide somewhere and say, I'm going to vote virtually. No. Let people come and vote.
How do we, Speaker, how do we cure a minority here in the House pronouncing themselves of a matter through voice voting while the number complements the quorum is not in the House? To put into effect the rule that colleagues are quoting that takes care of people in virtual attendance, we need an amendment that says for avoidance of doubt, they constitute part of the quorum if they are going to vote in those specific terms. Otherwise, if they are not voting those specific terms, they cannot be part of the quorum.
You know, what you're trying to do is to infringe on the role of members to vote. That's what we are trying to do. Yes, Doctor.
Yeah, thank you very much. Final.
Now let me give Jessica.
No, I am saying a final submission from me. Honorable Chair. Honorable Chair, it is very difficult, and it will be very complicated for the presiding officer to mix the two types of voting, sound and then numbers. How are you going to mix them? The only way those who are attending virtually can be part of those who are voting in-house is when one system of voting is going to be adopted. And
so are you in for the amendment or not?
No, I am just helping you to discern how members can bring these ideas of mixing two ways of determining numbers.
Okay.
So that we can know that in the amendment, the presiding officer will need to institute a measure of voting that is universal for those who are attending virtually and those ones who are attending. Otherwise, if at all we are going for ayes and nays, which Honorable Isa says ayes and nays, because the sounds are quite different there, then it will be difficult to include those ones attending virtually in that kind of voting.
Right Honorable Speaker.
Jessica.
Thank you so much. I have listened attentively. One thing I have noted throughout my stay in Parliament here is that the presiding officers try their best to maintain quorum in the House, whether voting through roll call or in unison when we say aye or nay. So the issue of quorum is constant. To Right Honorable Speaker, I don't know what exactly Madam Honorable Isa will wish to cure. Because if the quorum is maintained constant, we have never in one time gotten more members on Zoom than in the House. Therefore, Right Honorable Speaker, I see what he's proposing as redundant, because based on the practices through which we have been going through, quorum has been maintained constant. Thank you so much.
Thank you, Honorable Minister. Helen?
Thank you, Right Honorable Speaker. I want to say that the issue of quorum, according to my little understanding, is numbers and then voting. When we are voting aye and nay, truth be told, not everybody here shouts it, even if you are in the House. We only listen to the highest, and the Speaker says yes. But when something is contagious, usually the Speaker says we go for a roll call. And when they go for a roll call, even people on virtual are allowed to vote. Right Honorable Speaker, you interviewed me for minister through a Zoom. I did not appear before you officially. You remember? Because of COVID, I did it virtually. But you had, the committee had me, and we agreed. They answered the questions and everything. So the issue of voting, even that time of COVID, they would bring you a picture. When I'm saying aye, the way I am there, it will come. So I think let us not confuse aye and nay, because even the aye and nay, I have never tried to count who has said or not. It becomes hard. But for roll call, that one is individual. So sometimes we'll try to say aye, and the other one saying nay, everybody
There's
shouting.
information here.
Thank you.
Yeah, thank you, Honorable Minister. I wanted to give you information that even where the ayes are high,
It is only the Speaker
our
who hears.
presiding officers can hear the nays and declare it here.
Next item, next.
Rule 25.
25. It is only the Speaker who hears.
It's only the Speaker.
Jonathan Odur, Honorable. A root 1,000. OHT. 25. Rule 25.
I think procedure we have to take a decision on the Honorable Aisha.
No, I mean, let's maintain as it is.
Yeah, we have to vote on it. The question has to be put. She hadn't moved it.
We are not amending it. It was not in among the amendments that was there. It stands part of as it is.
Can we? We
that
need to put
we
a question.
vote. That we vote on her amendment.
We have to. We have to.
Okay, I am putting a question that we amend Rule 24, 24.6 as proposed by Aisha, Honorable Aisha Nalule Kawanda. Those in favor say on the contrary, nay. The nays have it.
Thank you very much, Right Honorable Speaker. That was in accordance with Honorable Dur's advice.
Dr. Dur.
So
25.
Rule 25.
Right Honorable Chair, Rule 25 is amended by deleting sub-rule 3 and 4. Justification to place it under the right rule, which is Rule 5.4. We are just interchanging the places.
Honorable Aisha.
No objection, Chair.
I put a question that Rule 25 be amended as proposed. Those in favor say and the court on nay. The ayes have it.
Part 6 of the rules.
Part 6 of the rules. The rules are amended by substituting for the title of Part 6 the following: paper and other items. And amendment of Rule 31, laying. Rule 31 is amended by substituting for the head note the following: laying of papers and other items. By substituting for sub-rule 1 the following: a member may, with the leave of speaker, lay a paper or an item on table in the House. To provide for laying of other items on table. 2, to require leave of the speaker to lay paper or any other item on the table.
Honorable Aisha.
No objection, Chair.
I put a question on the title of Part 6 of the Rules of Procedure. Be amended as proposed. Those in favor say and the contrary nay. The ayes have it. I put a question that Rule 31 be amended as proposed. Those in favor say and the contrary nay. The ayes have it. That is the same thing.
Rule 32.
Chair, you skipped Rule 30. Thank you. Rule 30 is amended by substituting for Rule 7 the following: the committee or minister in sub-rule 6 shall report back to Parliament within 14 working days from the date of referral of a petition for an urgent matter. And 2, by substituting for Rule 10 the following: the report of a committee on a petition shall be placed on the order paper within 14 days from the date of report. From the date the report is referred to the committee. Justification: to prescribe a specific time within which a committee or minister reports back to the House on matters raised in a petition. 2, to give a committee a shorter period of reporting back to the House on a petition. 3, to give priority to petitions in the House. This is to separate petitions, reports of petitions from other reports, because some petitions are of an urgent nature and they cannot wait for 45 days to lapse.
Right Honourable Speaker, it was our view that first of all business that comes to this House is important. It is not in a side that petitions are more important than other business that comes to the attention for consideration by the House. 2, if it is that important, the presiding officer may direct that they are given a shorter time. There is no reason to prioritize and say one, because we don't determine the petitions. Petitions just come outside this House. Some could even be frivolous, and we suspend very important or urgent meeting because a frivolous petition has come up. So we didn't see any need to have that. In any case, we thought that priority of business has already been given by the Constitution to be that the business is already provided for under the Constitution, and then the presiding officer and the Speaker has discretion, since the order of business and the order paper is a function
the order of business
presiding
is on 25, Madam Aisha Hajati. and kindly give the speaker the discretion, because if I know that there's something very important, like a leader of opposition can give me a document in the morning and I know it is important, I'll take it as a priority.
Most obliged, Right Honourable Chair. With the relator's respect to the due chair of the Speaker, Right Honourable Speaker, I just noted that by the time people petition Parliament, they have things that they consider very important to them that need to be disposed of. And sometimes matters are responded to when they have actually expired. I just thought it was very important that petitions be given due accord, disposed of early enough, and also proposing that a particular period of time be given to petitions was not take away the Speaker's power, because even in the rules, they already prescribed time, what should be handled when and when, so I thought falls there.
Honorable Shah, we shall handle it administratively where we feel that this must be handled as fast as possible. If it means handling it directly with the minister responsible, even without going to the committee, it should be done.
I concede, Chair.
Thank you. Next.
Rule 32.
Thank you very much, the Honourable Kavanda. Rule 32. Rule 32 is amending by substituting for the heading of the following: mode of laying and presentation of papers. Justification to include presentation in the heading notes so as to align with the contents of the rule. It's about aligning the head of note and the contents of the rule.
Thank you, Honorable Shah.
No objection, Chair.
I put a question that Rule 32 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
New rule.
Insertion.
Insertion of new rule. Part 6 of the rule is amended by inserting immediately after Rule 32 the following: 32A, laying of reports of the Auditor General. The Speaker, or in his or her absence, the clerk shall receive the report of the Auditor General submitted in accordance with Clause 4 of Article 143 of the Constitution. 5. The Speaker shall, as soon as practicable, cause the report to be laid before the House. Upon the report being laid, the Speaker shall refer the report to the relevant committee for examination. Justification. To separate the requirements for laying of the Auditor General's report from the functions of the Public Accounts Committee under Rule 174 and 181. To insert the reports of the Auditor General which are laid as papers under the right part. And 3, to align the submission of the Auditor General's report with the time frame in the Constitution.
Thank you. The first one, the Speaker, or in his or her absence, the clerk shall receive the report of the Auditor General submitted in accordance with the Clause 4 of Article 163 of the House of the Constitution. Is this report received in the House or it is received in the office?
Right Honourable Speaker, the report can never be received in the House. It can only be received in the office.
So it is redundant. Remove it. We know how to receive our reports there.
You see the role, we need to look at the... Can I have the role, the current role, please?
Let's deal with the procedure in the House.
Right Honourable Speaker, when you look at...
a definition of...
You have been receiving these reports as a... I think it should be under the Article 163, and you wanted to empower any other office other than yourself.
Have we complained? Have we complained? Haj.
We can concede.
Why are you taking Yeah. There is a speaker, there is a deputy speaker. Yes. There are also commissioners of HT.
We consider, Right Honourable Speaker, we can go to Rule 15.
Okay. So, no amendment there?
Yes, we've considered. We
Okay,
can leave that
next.
one. Part 7, I think.
Part 7.
The rules are amended by substituting for the title of Part 7 the following. Part 7, laying and presentation of parliamentary reports and reports of regional bodies organization, to align the head note with the content of the rules within the part.
Honourable Aisha.
No objection.
Question?
Presentation of parliamentary reports and reports of regional bodies, organizations. Why are you only
Just
putting regional bodies?
No, it's just aligning the head note. The justification
Parliamentary
is there.
delegations
The head note and the
abroad.
part itself. It's
Okay.
just aligning what is the content of the part and then the head note.
Okay. I put a question that the title.
Right Honourable Chair, I'd informally asked the chairperson to clarify on what he means by parliamentary reports. Because a report of parliament is a report that we have adopted here. If he means a delegation or a committee, or that report cannot be a parliamentary report. I don't know if he meant a delegation, because a delegation cannot bring a parliamentary report. would be a
Parliamentary report is what has been adopted in the House.
Yes. So if you say laying of parliamentary reports, do we lay that report to ourselves? So I would like to move the amendment that it would read that laying and presentation of reports of parliamentary delegations.
Yes. I put a question. Is that okay with you?
We had already discussed it with Jonathan and I had considered.
I put a question that the title of Part 7 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
Rule 33.
Chair.
Laying of reports of parliamentary delegations abroad. Rule 33 is amended in sub-rule 1 by inserting immediately after the word abroad the words parliamentary delegation. Justification is just for clarity.
Aisha.
I agree to the amendment.
I put a question that Rule 33 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
Rule 40.
40.
Rule 40 is amended in sub-rule 1 by substituting for the words 6 months the words 90 working days. In sub-rule 3, by inserting immediate after the word minister, the word responsible for the implementation of the treaty, protocol, or international agreement. In sub-rule 4, by deleting the words coordination and. Justification: to give a shorter period for a treaty, protocol, international agreement to be laid before Parliament after it is signed or concluded. 2, to clarify that it is the minister responsible for the treaty, protocol, international agreement that shall make a periodic report to Parliament on the implementation of the treaty, protocol, or international agreement.
Aisha.
I agree to the amendment.
I put a question that Rule 40 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
New rule.
Insertion of new rule. The rules are amended by inserting immediate after Rule 40 the following. 40A, ratification of treaties. A treaty submitted to Parliament for ratification under subsection 2B of the Ratification of Treaties Act shall be laid in the House, and the Speaker shall refer it to the relevant committee for scrutiny. The committee shall examine the treaty in detail and make all such inquiries in relation to the treaty and report to the House. 3. The report of the committee to the House shall include a recommendation that the House ratifies the treaty with the reservations or rejects the ratification of the treaty. 4. In ratifying a treaty with reservation, the House shall specify the affected provisions of the treaty and the proposed text of each reservation, which may include prescription of timelines within which an obligation to be fulfilled before implementation of the treaty. 5. Upon the resolution of the House on a treaty, the clerk shall, within 7 working days, notify the minister responsible for foreign affairs to enter the information in the register of treaties. Justification: to provide for procedure for ratification of treaties in accordance with the Ratification of Treaties Act.
Thank you very much, Madam Chair. Madam Chair, the information I have is that different protocols have different terms and conditions as regards treaty ratification. And different treaties are ratified, some by the executive, some are ratified by Parliament, some are ratified by us here, which is mandatory as a result of all regional parliament ratifying. So I'm seeking clarification from Honorable Budu. We need to be specific, otherwise this provision will be redundant. I'm also aware there is an act regarding ratification of treaties. I don't know whether you consulted.
Sure. Why don't I sort out the easier one? One, this particular proposal is based on the ratification of the Treaties Act, and whatever we have stated here is provided within the Mother Act, that you can reserve a treaty you can reserve the treaty. 2, you can ratify with reservations, and 3, you can reject it altogether. However, there are treaties which should come and which make it conditional precedent to be effective, to be ratified by parliaments. Those are the ones which are relevant to this rule. Those which don't, certainly they cannot come here because there is no legal requirement for them to be here.
Thank you. Yes.
Right Honourable Speaker, Chair, I need some clarification from the Chair of Rules regarding the role of the committee and Parliament after a treaty has been signed. Not ratified, but signed, because the two are different under the law of treaties. The proposal is that at ratification we can examine and the like. But ratification of a treaty is really at the tail end of the process. Tail end of the process. Chair, wouldn't it be proper for a parliamentary committee to begin considering this treaty in a draft form? In a draft form. So that those who negotiate the treaty on behalf of the country do it with input of Parliament. To suggest that Minister X is in Addis Ababa and the technical team have negotiated the treaty, have even signed it, and we are bringing it here for ratification. And at ratification stage, we are making proposals for reservation. In my view, Chair, would be making it very cumbersome for our representatives in the negotiation of these treaties. Wouldn't it be proper, Chair, that it is considered at that stage?
Honorable Asumani, can you look at the ratification of Treaties Act, Section 2 and 4?
Right on, Speaker.
All treaties shall be ratified as follows: by the Cabinet in the case of any treaty other than a treaty referred to in paragraph B of this section, or by Parliament by resolution, where the treaty relates to amnesty, neutrality, or peace, or in the case of treaty in respect to which the Attorney General has certified in writing that in implementation in Uganda would require an amendment of the Constitution. Then 4, treaties to be laid before Parliament. All treaties ratified by the Cabinet shall be laid before Parliament as soon as possible.
Chair?
Chair, before I come in, can we have benefit of somebody who has
Yes.
worked?
Thank you.
A
With your
diplomat.
permission.
Yes. I have read the proposal, and they put into consideration the Ratification of Treaties Act and the Constitution. What the Rules Committee has done is to realign the procedure concerning ratification of treaties in the House. And there is apparently nothing that is deviant of anything. So the proposal as it is crystal clear. Whatever that Parliament needs to do in as far as ratification of Treaties Act is concerned, that is the procedure.
Thank you.
Thank you.
Thank you.
Can I, you see, let me answer even Honorable Asumani Vasalirwa Hajj with all the 2 wives.
Honourable members, I put a question that the proposed new clause be inserted as proposed. Those in favor say on the contrary, nay? The ayes have it. Before you start talking about your wives.
Rule 41.
Yeah.
41.
Yes, right, Honorable Speaker.
Yes, Haji.
We all that's what they actually do even during loans.
Haji has just come, by the way, Asuman.
Okay.
From one.
Rule 41.
41. Honourable members,
Prime
let's
Minister's time.
move.
Rule 41 is amended. By inserting immediately after sub-rule 3 the following: a written or oral question to the minister, to the Prime Minister rather, shall be precise and concise, and shall not address more than one matter of government policy or general performance of government. In sub-rule 4, by substituting for the word 15, the word 10. By inserting immediately after sub-rule 4 the following: 4A, the Prime Minister shall answer the question in a precise and concise manner. B, in sub-rule 8A, in paragraph A, by substituting for the word 40, the word 20. 2, in sub-rule, in paragraph B, by substituting for the word 20, the word 40. Justification: to discourage argumentative questions and elicit precise and concise responses from the Prime Minister. 2, to allow for interactive debate. And 3, to give more time to oral questions during the Prime Minister's time.
Ajat.
Thank you, Chair. I propose that Rule 41 be amended by substituting for Rule 8A the following. The 60 minutes referred to under Sub-Rule 8 shall be for responding to oral questions. 2, by inserting immediately after Sub-Rule 8A the following. Where the Prime Minister does not provide an immediate response to an oral question, the Prime Minister shall provide a response to the oral questions not answered in the next Prime Minister's time. Justification: to restrict Prime Minister's time to only oral questions. 2, to require the Prime Minister's time to provide for response in the next Prime Minister's time. Since we have a debate, I can explain a little. The difference is that majority is proposing that time for oral questions be expanded and minimized for written, whereas I am proposing that Prime Minister's time entirely should be oral question or answers. In the event that the Prime Minister is unable to answer the question, she should provide the response to the following. Prime I submit.
Yes.
Madam Chair, I want to thank the two members. But my interest, if members agree, that is on the issue of written question, Madam Chair. I would pray that the Prime Minister comes here, responds to all written questions with no short response from the member who gave it. For me, I would seek for an amendment, if passed, that the Prime Minister should only read oral questions from members who are present in the House. Because sometimes the Prime Minister comes and reads questions, members who ask them don't appear and spends time. But if a member gave an oral question and is around, our rule should give that member, as by the powers of the Speaker, some few rider time to respond to the Prime Minister as per her response, to give us a good debate. But what's happening here, the members will feel so bored when the Prime Minister is responding to written questions. She reads and goes away. But I would pray we have a rider of a member. If I'm around, if a member who is not around and gave an oral question, that one should not be entertained. But a member who gave an oral question and the Prime Minister responds on the written question, she gives a rider to move with the prescribed time as by the powers of the Speaker. But yes.
Madam Speaker, I want to concur with the Honorable. Many times, Seungu, Gonzaga. Yes.
Mukatuliki.
I want to concur with Mukatuliki with this rosary because he always speaks his mind. Madam Speaker, many times the Right Honorable Speaker, I mean Prime Minister, comes and reads responses to the oral questions. And they are always very long. But it is always also important to give the persons who've raised those questions to raise rejoinders, at least, because at the times the Right Honorable Prime Minister reads. Let's provide a little time at your discretion. And if it should please you, we consider that, such that the Prime Minister can harmonize with the person who asked the question and have an answer that is convenient. I thank you.
Madam Teacher.
Thank you very much, Madam Chair. Madam Chair, I totally agree with Aisha's oral, the Prime Minister's Honorable Aisha's recommendation that we have totally oral questions during the Prime Minister's time. However, I have an issue with still the Prime Minister's time, and I am begging that we reconsider and amend somewhere that the Prime Minister needs to be giving us feedback on her commitments within a particular range of time. Because there are incidents where we ask the Prime Minister questions and she assigns them to particular ministers, and those assignments are never catered for. And then you have the same queries day in, day out. So can we designate the Prime Minister to her commitments and her minister's commitments within a particular period to be worked on and come back and give us feedback on whether they responded to those issues or not, so that we avoid members of Parliament coming here lamenting all the time that they've raised issues to the Prime Minister during her time and and the ministers never respond, thereby repeating the same issues during that time. Thank you very much.
Yes.
Thank you so much, Madam Chair. Madam Chair, I'm also here to concur with Honorable Aisha that let Prime Minister's time be for oral questions. But I also suggest that we make the written questions forwarded to Prime Minister, and we put here that in a month's time, she should have responded back written to that very person who asked the questions. In 1 month's time, then it's forwarded to the pigeon hole, and the PA informs that, Madam Honorable Nalima, your response has been delivered in your pigeonhole, or please pick it from private. So that now it's entirely our time. Thank you.
Those are public questions. It shouldn't be private. Yes, Sarot.
Thank you, Right Honorable Chair. Right Honorable Chair, I would like to agree with my colleagues that whereas it's important that the Prime Minister's questions are given so that she can provide written answer. But Right Honorable Chair, the Prime Minister is the leader of government business. The Prime Minister should be understood as the Chief Minister to know substantially so much that is going on within the sphere of running of government. So it is important that in certain instances here, questions are asked of the Prime Minister and that they should be able to rise up and give spontaneous answers to some of the issues that the members would like to know. Because, Madam Chair, some of the problems we have is that the members raise questions that require answers that are based on the knowledge and wit of the Prime Minister. But because they are written so that they are later answered afterwards, the technical people go and write generic answers that are supposed to soothe the members of Parliament. Right, Right Honorable Chair, I want to agree with my colleagues that we have the questions responded to in two spheres, that those that require of the Prime Minister, just as she is here, to spontaneously get up and tell us what is happening, probably in Karamoja, or what is happening in Isinjiro. Because as a leader of government business, a Prime Minister should have sufficient knowledge of what goes on in government. I thank you, Madam Chair.
Right Honorable, I agree with what he's saying, but sometimes there are questions whereby you need to investigate on them. You need information. Then you come here and you say, please give me some time. So if we go with what the Honorable colleague is saying, then you will end up postponing most of the questions. Can you wait for some time? Can you wait for some 2 days? Thank you.
Yes, Mehdi.
Thank you, Right Honorable Speaker. Right Honorable Speaker, what the Prime Minister has stated is also an answer. You raising up and orally responding that I don't know, I'll go and carry out investigations, is an oral answer in itself. Therefore, what the members want, why there are Prime Minister's questions in parliamentary democracy, ours is a hybrid, is to check the following. One, the alertness of the Prime Minister and the front bench. Two, coordination. Three, response to the nation in real time. And that is why it is designated time for you, so that you fit purpose. That is why when you come to Parliament to be approved in that position, those are some of the considerations we make. Is she alert? Is she aware? Is she knowledgeable? Now, as the head of government business, you must be knowledgeable in every corner of every government department And if you're not, then you respond and say, Honorable Member, I clearly accept that matter touching this issue. I'm not enlightened, but I'll come back with an answer. That's also a response. But those that you ought to know, for example, if someone rose up and asked, Right Honorable Prime Minister, how many referral hospitals do we have? Do you really need to go back and say, I'll come back with an investigative report to tell you how many referrals we do have? That must be off cuff. No, I'm trying to give you the view, the rationale that there are some things people check from the Prime Minister to see whether she's up to date as the leader of government business with every department, with every ministry and governance of the country.
Thank you. Jessica?
Thank you so much, Right Honourable Speaker.
After you.
I put my questions to the Prime Minister to get update on actions being taken by government, but not testing the capacity of the Prime Minister. No. Therefore, I support the committee recommendation with an amendment
Of the timing.
that let there be provision for supplementary questions so that it becomes lively. Then to Right Honourable Speaker, there is an avenue that we are not utilizing, asking direct questions to the ministers. Because I feel there are questions that we can straightforward present to the ministers. Right Honourable Speaker, those are the two proposals I have. Thank you.
We have a provision for supplementary questions on 48, Rule 48. Supplementary questions.
Madam
Yes,
Chair, Madam Chair, I would like to agree with most of my colleagues. Most countries, majorly Commonwealth parliaments, where Uganda is the sample too, prime ministers are students of government business. Are students of government business. I call it so because they get briefs from ministers on a daily basis in each sector of government. Lucky enough, Madam Speaker, lucky enough that in Uganda, Madam Chair, lucky enough in Uganda, they can appoint anybody to be a prime minister, even macho. But in other countries, your IQ must be measured to the capacity that you understand. No.
My Prime Minister's IQ is very high. You get it, eh? My Prime Minister is very, very high.
Madam Chair, I've not attacked anybody.
No.
I'm just talking.
Can you sit?
Madam Chair, I've not attacked anybody, but I'm saying even macho.
You sit.
Even macho,
Sit.
it is.
Can we get a middle ground?
Right Honourable Speaker, I wanted to allay fears of colleagues that have had submitting. The proposal for oral questions actually takes care of the fear of one of the members that he talked about, that sometimes the Prime Minister comes and answers questions to members who are not even present. In the case of oral question, oral answer, there's no way where a Prime Minister will come to answer a question to someone who's not present, because you are asking the question and it is responded to. And to members who want very detailed and well-researched questions, we still provide for questions to ministers. Those questions can go to the ministers. So this takes care of what we want, that the Prime Minister's time is oral, 60 minutes, lively, interactive, and we get spontaneous answers.
No, we don't do away with it. Yes, Chair.
Can I clarify?
Yes.
Colleagues, the purpose of this amendment is really just not to open up a general debate. Whereas the Commonwealth practice is Prime Minister's time is only oral. in our own wisdom, at the beginning of this particular term, there was some innovation to provide for written questions. What the House did at that time was to provide 40 minutes of the 1 hour to be dedicated to written questions. And oral was left with only 20 minutes. That is the hybrid which was introduced this particular term of Parliament. However, in the committee's wisdom, we have found that we should change it and have 40 minutes now for oral, the one you are trying to justify. Then the written, we have reduced it from 40 to 20 because you only have 60 minutes. That's the purpose of this amendment. Because it addresses both concerns in our view.
Thank you. Aisha. Yeah, there's a better ground.
Right, our speaker, we are moving to the right direction. If the mayor's opinion think that swapping minutes is fine, it's okay, I concede. Otherwise, I would have preferred all the 60 minutes.
Madam Chair.
Yeah.
Madam Chair.
And
Madam Chair, I have an amendment to propose on our rules, sub-rule 3 and 4, particularly
that
4,
is
on the Prime Minister's question time.
yes.
3. Because 4 says
Photo
that
one.
the clerk shall enter all the Prime Minister's questions and shall conduct a raffle, selecting only 15. My amendment is to delete and allow the clerk to forward all questions to the Prime Minister, because subjecting
They have
a
reduced
member's
now to
question,
10. According to the amendment, they have reduced to 10.
even
Only
yes,
10.
that's why I'm opposed. Even that reduction to 10, because a member of parliament, that is infringing on my right as a member of parliament to represent my people. I can represent through a question or which I've written. So if somebody else is going to sit in the office and then determine and say, now this question should not go
This
to the Prime
Oduru.
Minister.
Oduru's
Yes.
question.
Yes, maybe for other reasons. And then the next Thursday, another set of questions comes. It is like vetoing my privilege as a member of parliament to be able to ask questions. So I propose that it should read that the clerk shall enter all questions in the Prime Minister's question record book and forward all the questions to the Prime Minister, so that everyone who has asked a question gets an answer. Yes. Because now a raffle, by the way, Chair, when you talk of a raffle, this is now gambling, which is also illegal now.
Why don't we do in a month, dedicate one whole Thursday for the Prime Minister to answer all questions on top of this? Yes, bring the amendment.
Right, Honorable Chair. Sorry?
Blend. Honorable Formalo.
Thank you, Madam Chair. Madam Chair, it is only unfortunate that we don't have ministers in this house whenever we are deliberating. But otherwise, Prime Minister's question time is supposed to be purely oral. Those written questions should go to the ministers to respond to questions for oral answers. That was what the practice was before. In the 10th Parliament, in the 9th Parliament, and even in the 8th Parliament. Prime Minister's questions time, if we decide to make those written response, it's going to take a lot of our time. Even when you say 20 minutes, they will extend it to even 40 minutes again. They should give us time to ask as many questions as possible, and it should be oral. Thank you.
Can we agree that first of all we have agreed on the time that has been proposed. Not so. 40-20. 40-20. And 10. But the mode of selection is what is yet to be what? Agreed upon. And yes, before Lope you come, let
Madam
me
Chair.
have Doctor and Chut.
Yeah, Madam Chair, thank you very much for having some good time in order to discuss this. I would rather propose that we even increase time for the Prime Minister to answer some of these questions. Madam Chair, give me just a minute. I am not for the idea that it is just a ritual that the Prime Minister answers simply because you want to check on their alertness. Rather, to get substantive answers, well researched, so that these questions can attract real answers. So that those answers can also
answers and
inform.
actions.
Yes, those answers can inform the kind of actions to be taken. But
No.
merely to allocate
No,
time.
if
just
my question
because-
has been there with you for over 1 week, and there is a disaster in my village, I expect you to come back and report, yes, my team went to this village, and this is what was done. Report action.
Yes, right, Honorable Chair. But I believe that questions for oral answer are even more than that. Somebody talked about the alertness, well-researched and having information. Sometimes you may not have this information, and you need the technical officers to take notes, do the research, and relay this information. I'd rather we increase the time from 1 hour to 1.5 hours so that the Prime Minister has sufficient time to answer Parliament. We are very many, and this country has a lot of people who want this representation.
We have a lot of business. Chut.
Thank you, Right Honourable Speaker. Right Honourable Speaker, on the issue that Honourable Dul has raised, I want to propose that all the questions be accepted and then they be responded to. However, within the 20 minutes, the Prime Minister can read out the questions, but then lay the responses, in case there are very many, so that within the 20 minutes, all those questions are accommodated itself. Thank you.
Lope. Before Lope.
Thank you, Madam Chair. Madam Chair, I want the attention of the chair here. Chair, I want your attention. Madam Chair, I want to bring the attention of the chair to Rule 50 of our rules. Rule 50. Rule 50, Madam. Yes, and specifically, I want you to look at sub-rule 3. And Madam Chair, why my colleague Dr. there is proposing that we should even extend the time for Prime Minister is because we will not use this rule. If the ministers were answering questions on Wednesdays, then the Prime Minister will have enough time to answer the remaining questions on Thursdays. So I think, Madam Chair, you need to consider Rule 50 sub-Rule 3 and give ministers a chance to answer questions on Wednesdays. Then the Prime Minister can have enough time to answer questions on Saturday. I beg Chair to make a comment.
Right Honourable Speaker, my honourable colleague raises an issue, but looks like many of us are interested in asking the Prime Minister. They rarely ask the ministers the question under our rules. They rarely. Everybody now has to run to the Prime Minister, thinks that's where the solution is. That's number one. Number two, as we express our discontent about sometimes the performance of the Prime Minister, I want to draw to your attention that we are proposing an amendment that a written or oral question to the Prime Minister shall be precise and concise, and shall not address more than one matter of government policy or general performance of government. When you listen to some of the questions coming, actually they offend this. They really offend this. So, if we are to do reforms here, we need to look at also ourselves. What sort of questions are we asking the Prime Minister? Are they the questions that would require a Prime Minister, or even a question that would require a minister? And there is, under the rules, you can ask a minister a question also. So, on even 2 days, and yet the Prime Minister, you only have 1 day and 1 hour. So, the challenge is on both sides. And I think this is an opportunity. This should be a learning process for all of us, such that we know that we only have 60 minutes, and how do we utilize them?
Much for giving me the chance. Thank you very much, Honorable. Right Honorable, the information I'd like to give my colleague is that more often than not, the Prime Minister has always been referring questions to the ministers who are here. She will say, so and so, can you answer? Mr. So and so, can you answer? And it has always happened. So that means the ministers must always be present and they must be current when it's the Prime Minister's time. Thank you very much.
Just information, just some information, Chair.
Hello.
Some information.
Honourable Speaker, I think what we are trying to remedy is 2 of the 4 cardinal roles of an MP, and we are trying to see how we get everybody encapsulated therein. Number 1, oversight and representation. Members are asking for a bit more time to be able to represent their constituents, to be able to put to government questions that are of concern to them, and that way representing their people. Now that, because you see, even Rule 50 is rarely followed for ministers and so on, for the obvious time, the order paper gets closed. How about
it is not the order paper getting.
It's our business generally.
No. Which minister will you ask now here?
Let me. We have our most of the time ever present Deputy Prime Minister, who is helpful at times, and other times he says, I'll look for the minister, and then I don't know. But can I suggest an amendment to Rule 41, in addition to Prime Minister's time? If it would make sense to look out for a day, maybe a month, in a month, 1 day a month, and we say we are dedicating this day to Prime Minister's question time. And then the Prime Minister makes sure she is present with all her ministers, or at least every docket gets to be represented on that particular day, so that members are asking questions, whether it be oversight, whether it be representation, whatever issues there are, that day, in addition to Prime Minister's time, the Prime Minister is available, and then these questions, that day we get to focus on that business.
Thank you very much, Madam Chair. I think what the law is suggesting is pertinent. However, the order paper is a function of the Speaker. She can dedicate a whole day to the Prime Minister, all our business. Say this shall be this and this. You get it? So that can happen. It may not be routine, but if, for example, if we had accumulated a number of questions, they could be like 100 written questions. How do you expect the Prime Minister to answer them in 1 hour? So the Speaker at that time can say, if the written questions are over-accumulated.
Can I help you?
Oh, sure.
Much as the Speaker has the power, and the issue of order paper is on the Speaker, let's institutionalize it. so that it compels somebody to be here. Not like the speaker is forcing somebody to be here. Let it be an institutional matter.
Right, Honorable Speaker, I have not seen what you are seeking to cure because it is us that
No,
have
we
not
are discussing what we
That's what I'm talking about. It is us that have not utilized Rule 50. Rule 50, you write questions, send them to the minister will come here and answer.
Yeah.
If we utilize Rule 50, we would be answered. We have not utilized it.
The number of members is big, Aisha. 1 hour a week is not enough. But what Lop is saying, on top of the 1 hour in a week, if we can have a day in a month, say end of and dedicated to Prime Minister's time and ministers.
Would that mean taking away the Thursday or would sustain the Thursday?
No. In addition.
In law, we call it the mischief rule. What is this we are trying to cure? Is it that the question time is limited?
Yes.
That there are many questions that have not been answered?
And there are many members.
And therefore, the 1 hour a week is not enough. Then what are the options? One, we can increase on the 1 hour. That's the first proposal. A week. And we say 2 hours or even a whole 2 hours, 3 hours a week. Or we can, let's have just options. Or you can say we can have 1 day, the last day of every calendar month, on a Friday, on Thursday, or the beginning of Tuesday, we can dedicate that day to Prime Minister's time. So either a week or a month, or I'm giving 3 options before the Prime Minister comes in. Whether we increase the 1 hour a day, meaning it will be once a week, or we dedicate a whole day once a day, once a month.
Madam Speaker, Madam Speaker, we represent our constituencies here. And many times we have problems. And some of these problems are matters that tend to be of urgent importance. And we would really want to raise them. So how I wish, like you've proposed the chair, Madam Speaker, you dedicate 1 Thursday in a month specifically for members issues, raise their concerns. The Prime Minister comes here with her whole team and everything is answered. However, those answers should be action-oriented. Action-oriented. Because there are also answers that are given here that just pass. They just pass. So if we dedicate this, the Prime Minister will be duty-bound to give answers that even our communities should hold government accountable for the answers that will be given. That one day in a month will be good. Then there has been a question, Chair, a question of how much time.
First, before you go there, we accepted on the one of Thursdays, we are not changing, not so? With the 40-20-10 questions. That is unaccepted. That's the accepted one. Okay? Yes.
We expect the proposed amendment, or we have gone back to the original one?
We have accepted the proposed amendment.
Okay. Then in
Then, in addition to the proposed amendment, we have 1 day in a month that we dedicate to the members. We dedicate to the members for oral and have the Prime Minister with the ministers. And the question is for the front what? Is that acceptable to members?
Chair, before she comes in, before you come in, on the first amendment, Right Honorable Chair, where I conceded to a 40-20 arrangement, there was a question raised by Honorable Bukonja, Dr. Lulume, for where the Prime Minister is unable to give spontaneous answers to those questions. I pray that the amendment I had made on 8B be sustained, which said that where the Prime Minister does not provide an immediate response to an oral question, the Prime Minister shall provide the response to the oral question not answered in the next Prime Minister's time.
That's okay.
That will take care of his worry. Thank you.
That's okay. That's okay.
Madam Chair,
no, you're going to come. You're going to come.
Additionally, I would propose that on that very day when we are having the whole day for the Prime Minister's time, we include the backlog of the oral questions which were not answered. We put them so that on that day,
That
the
is
Prime
now
Minister...
administrative. That's administrative.
Agreed.
Yeah, thank you. On the same?
Right Honorable Chair, I wanted to inquire, to get clarification from members. By nature, some questions are of emergency. Those emergencies that occur, how are we going to handle them? Should we wait for that 1 month to handle the emergencies?
We have matters of urgent importance.
Chair.
Yes.
Chair. On the amendment as proposed by the Right Honorable Leader of Opposition, I pray that we merge it with a matter that Honorable Madam Teacher Flavia was talking about, the issue of action taken. On that Thursday, that last Thursday in a month where we are dedicating time to the Prime Minister should provide to the House action taken to the questions that have been raised during the month. Yes, should be part of the report and then answer other subsequent questions.
Exactly. Yes. Honorable members.
Procedure.
Honorable members, I put a question that Rule 41 as be amended as proposed by the committee, modified by Aisha, and further modified by the LOB. Those in favor say and the contrary nay. And Jonathan, and Honorable Jonathan Odur. Those in favor say and the contrary nay. The ayes have it.
Rule 54.
Right Honorable Chair, we still have a long way to go.
And we need to move now.
And
Honorable Aisha, which other rules are for?
My view.
Where are you dissenting? They are over. Okay. Now you need to move faster.
I was making a suggestion, Right Honorable Speaker. Having gone through this exercise for some time, I know at some point you get a little bit clogged. Members are alert, yes, but they are not as alert as when we began. I do propose that if at this point we can go and reflect over to the remaining amendments so that when we come back tomorrow, we'll be fresh. I think to do us better. There are very many remaining. Very many remaining. On this point, I would move that we adjourn at this particular time. And the reason, Right Honorable Chair, why I'm moving this, I can see there is a lot of enrichment to the report, to the discussion going on, and we don't want to lose it out. So I do propose that the House resumes and the committee reports there too.
You mean this motion is seconded like this? I can mention names: Millie, Tony, Christine, even UPDF, even the prime. Okay, seconded by 3/4 of the House, including Oduru and Loeb. I now put a question that the House does resume and the Committee of the whole House reports there too. Those in favor say and the contrary nay. The ayes have it. Again, somebody is saying nay.
Report of the Committee of the Whole House.
Right Honorable Speaker, I do report that the Committee of the Whole House considered amendments to the Rules of Procedure of Parliament and passed 19 amendments with some slight amendments.
With amendments.
19 clauses with slight amendments.
With amendments.
With amendments.
Motion for adoption of the report of the Committee of the Whole House.
Right Honorable Speaker, I move that the report of the whole House be adopted.
I put a question that the report of the Committee of the whole House be adopted by this Honorable House. Those in favor say and the contrary nay. The ayes have it. Honorable. Honorable members, just reiterate what I said before. Section 4, subsection 1B of the Leadership Code Act 2002 requires a leader to declare their income, assets, and liabilities to the Inspector General of Government every 2 years during the month of March, and prescribes penalties and for breach of leadership code. That includes, among others, dismissal from office, vacation of office, confiscation of excess or undeclared property. Honorable members, I want you to take note of the following. 1, declaration under the Leadership Code shall commence on 1st March close to midnight, that's 31st, and it will close at midnight of 31st. Mandatory legal obligation must be complied with to avoid penalties under the law. Strong advice to prepare records and ensure early filing of electronic forms to avoid last-minute rush, because you know very well the system can crash. The clerk to Parliament has made arrangements to support the members using IGG online declaration system, that is IGODS. ICT Resource Center shall be organized at the center to enable members to help during declaration. The team is going to be led by one of the assistant directors, Julius Wabwire, and is on 0772 57 03 66. Wabwire Julius. Mr. Wabwire Julius. 0772570366. Kindly